Can everybody hear me? Is it good? Thank you. Okay, this evidentiary hearing will now come to order. You know, this is great. We got a whole church full of people. That's a great sign. Maybe we ought to do this more often. No, just kidding.
First time since Easter.
Yeah, just kidding. As we normally do, we'd like to start this with a moment of silence. We ask Bill to say us an invocation.
Let's bow together as we pray. Father, this room we're meeting in tonight is a historic room, Gaither Chapel and now Graham Chapel. A lot of sermons have happened in this room. A lot of Bible studies have happened in this room. A lot of concerts have happened here. I pray that tonight we would not break the history of this room by sin. I would pray several things, Father, for us tonight, all of us. I pray that number one, you would give us wisdom, unusual wisdom to see things clearly. I pray, secondly, Lord, that you would, out of that wisdom, bring truth. We live in such a day of untruth, people wondering, what is true? What is true? Give us tonight the ability to see what is true, true. Not just truth the way we see it, but truth the way it looks from heaven. And then I pray thirdly, Father, that tonight you would give us unity. Help us to see, Father, that we're friends, we're not enemies. Give us grace to be friends. And I pray that tonight you would deliver us from the spirit of silliness. Meetings like this often degenerate into silliness, silly arguments, silly words. Give us tonight, Father, your Holy Spirit, who will give us not silliness, but truthfulness and realness and genuineness. Give us wisdom. I pray that you'll come be among us. We ask all of this in the name of Jesus Christ, our Lord and Savior. Amen.
Amen. Well, the first thing we got to do, it looks like we have a quorum. We have a quorum. Like to thank everybody for showing up. This is the second meeting that everybody's been here, and we know it's an important thing, and we appreciate it. First item on the agenda is for the agenda adoption. To adopt the meeting agenda is presented. Do I hear a motion?
So moved.
Second is the minutes adoption from September 23rd, 2021, the meeting minutes, the variance on 314 Lookout Road. Do I hear a motion?
Move.
Second. Okay, very good. Well, why are we here? The first thing I would like to do is introduce us. We live here. We're part of the community as well. How we got on this board, we don't know. I'm just kidding. But anyway, so what I'd like to do is go down the line and like you introduce yourself. And we'll start on this way.
I'm Margaret Waterstrat. I live on Swanee and looking forward to chatting.
I'm Ann Kelso Hewitt, and I live on Swanee.
My name is Bill Solomon. I live on Assembly Drive, where the bench is that you walk past when you go on the trail. I've lived here since 1949.
My name is Mark Spence. I live at on McGill Drive, and I've been here about 7 years. And I loved Montreat from the time that I crawled up on Rattlesnake Mountain and looked over the hill and said, "Ooh, that's a nice place to live." So we appreciate you being here.
My name is Robert Solaski. I live on Chapman Road, which is just up the hill right that direction.
My name is Eleanor James. I bought the old McTighe house on Nisbet, if you knew the McTighes, about 20 years ago, and moved here about 5 years ago.
I'm Martha Chastain, and my home is up on Appalachian Way.
And next, we'd like to introduce the staff for everybody. So if you could, just tell us who you are.
Scott Adams, I'm the zoning administrator for the town.
Where's Alex? Is Alex here?
I'm Alex Carmichael. I'm the town administrator for Montreat.
Thank you, guys. Well, why are we here? The board will take up a request of the Mountain Retreat Association for a special use permit for the construction of a new lodge that will replace 3 existing lodges on certain property situated on 309 Collegiate Circle, Montreat, North Carolina. By state law, this hearing is quasi judicial. What does that mean? It's like a court hearing. You have to be follow certain guidelines and rules that the state puts out by law. The state's laws set specific procedures and rules concerning how this board operates. This board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is made upon the facts presented as opposed to opinions, facts that are presented. And we are also constrained by the standards of the town's ordinance. That's what we use, the law. If you will be speaking as a witness, please focus on facts and standards, not personal preference or opinion. Our job is not to quash anybody's opinion, but we have to follow the rule of law here. And that rule of law states that we have to look at facts. For certain topics, this board needs to hear opinion and testimony from expert witnesses. So you can say the sky is purple, but you're going to have a rocket scientist or somebody that says why and has been trained in why the sky is purple. The topics may include projections about impact on property values, projections about increased traffic, protections about what the long-term Montreat standards and goals are. Individuals providing expert opinion must provide factual evidence upon which to base their expert opinion. This meeting is open to the public, and we're glad you're here because, you know, we've been talking all this time about the past 100 years. Let's talk about what we're going to do in the next 100 years. The meeting is open to the public and everybody is welcome to watch. However, participation is limited to the parties with legal standing. Now, how are we going to determine this? I'm sure a lot of folks have heard this. The applicant, property owner, and local government have standing. Let me repeat that. The applicant, property owner, and local government have standing and can participate fully in the hearing. Other individuals are entitled to participate in the hearing, but only if it can be shown that they have standing. Evidence of standing may include proximity to the subject property, damage to the property values of an individual seeking standing, and secondary impacts. If any individual wishes to seek standing to participate as a party, please advise the board at this time so we can call on each person individually to provide evidence which would establish that you will suffer special damages distinct from the rest of the community for the proposed development. Now we have a list here of folks that put their name to the list.
Yeah, Mr. Chairperson, I think maybe that council has a stipulation about a few folks with standing that we should probably address immediately prior to going through that list.
Okay.
So council wants to address, Mr. Chairman, or the board.
Okay.
You hear me all right? It's worked out now rather than later. Okay, can you hear me? Okay. Oh, that's much better. Thank you. All right. So, Mr. Chairman, members of the board, my name is TC Morphus. I am the attorney here on behalf of the applicant, Mountain Retreat Association. I've conferred with the attorneys representing Ms. Hayner and Mr. Jones. Ms. Hayner lives at 319 Assembly Drive, and Mr. Jones lives, give me his address again, Mr. Newman. Yeah, so 314 North Carolina Terrace. We are willing to stipulate that they have standing to participate as parties. There have been a number of other affidavits, Mr. Chairman, which I believe you're going to speak to in a moment. The ones that we have seen, there are 2 affidavits by other members of the Hayner family. Also, I believe have an ownership interest in 319 Assembly Drive. We would say they have the same standing that Ms. Hayner, who's represented by council, has. However, a question I would ask is, are they seeking to merely present evidence as a witness, or are they seeking to participate fully as parties? As to the other folks, we think that they do not have standing to participate fully as parties. If they wish to, again, just present testimony as witnesses, no objection to that, sir.
Can you restate those names of the 2 people you
Certainly.
consent to?
So there are 2 property addresses,
Right.
319 Assembly Drive, that is owned by the Hayner family. And there are several siblings and relatives. And we would say that everyone from the Hayner family, 319 Assembly Drive, we would stipulate has standing to participate as a party. And then 314
314 North Carolina
Terrace, Mr. Jones, we believe also has standing to participate as a party.
And what, I'm going to ask the question, why does the other folks have, what is your reasoning?
We would need to see more information from them on their affidavits, and these are lay people speaking, so I understand there may be some confusion about what's being asked. They checked the box that said, we'll suffer the same damages as everyone else in the community. And in fact, it appears to be true. We talk about traffic, property values, noise, things that would affect a broad swath of the community.
So is your issue no new information? It's repetitive or no new information? Is that what you're saying by having multiple family members?
Well, there's 2 questions there, sir. Thank you for asking. So folks, we're not affiliated with the Hayner family, with the Jones family. We think they need to show that they would suffer damages distinct from the rest of the community, which is the standard, essentially special damages. And we don't think they've demonstrated that. Now, if they want to present testimony today, we're happy to listen. As to the Hayners, as I understand it, and this may be a good time for Mr. Whitlock to jump in. One of the relatives, the siblings, has retained counsel, Mr. Jamie Whitlock, and others have not. Mr. Whitlock, do you want to take over?
Thank you. Ladies and gentlemen of the board, my name is Jamie Whitlock. I'm an attorney with Davis and Whitlock out of Asheville. It's my pleasure to be before you all this evening and perhaps for the next week or 2. As has been stated by your counsel and by counsel for the MRA, I represent Mrs. Kate Hayner, who is one of the owners of the property immediately adjacent to the proposed MRA hotel proposal. That property is located at 319 Assembly Drive. I do understand there has been, I believe, 2 other applications for standing filed by members of the Hayner family. I do not represent those other members of the Hayner family. So I think perhaps it might be best for the board to inquire with those members about, with those other 2 members of the Hayner family as to exactly what their intentions are Obviously, on behalf of Ms. Hayner, I intend to present witnesses, cross-examine witnesses. And as council mentioned, we've reached a stipulation as to Kate Hayner's standing for the 319 Assembly Drive property. Again, I don't represent the other two individuals, and so I think the most prudent course of action would be for the board to inquire with those individuals as to what their intent is.
It's a good point.
Mr. Chair, if I might just have a moment to round out the folks who are represented. I represent the Jones family. That's Harry T. Jones, William Powell Jones, Margaret Jones Berry, and Nancy Jones Fox. And we submitted an application, an affidavit, that I believe is in your packet. And those are the individuals associated with ownership at 314 North Carolina Terrace, where council have stipulated to them having standing. And I just want to clarify for the record that those are those four names of the ownership that have applied for standing. And we would just ask that application affidavit be admitted into the record as part of this process. I can.
I'm sorry, what was your name again, sir?
John Noor. Is that better? Noor, N-O-O-R.
Mr. Chairman, I have the application for standing for the individuals associated with 314 North Carolina Terrace. I also have the application for standing for the single individual, Kate Hayner, at 319 Assembly Drive. So we can introduce those into evidence. There's been a stipulation. As indicated, the next would be, unless other council has something to say.
Thank you, Mr. Milton. I had just one other point. We've stipulated that they have sufficiently showed special damages for purposes of standing. To the extent their affidavits are admitted for anything else, namely sort of for the merits of the case, we would object and say that they need to present competent material, substantial evidence. But for the purposes of standing, we've stipulated to that.
And there's a discrepancy. Someone said 4 owners, you said 3 owners.
If Mr. Noor said 4 owners, then that is correct.
I'm sorry.
Yeah, I don't think it's not time to entertain questions from the
No.
audience yet. What I would ask the board to do is, I think the package will deliver to the board that have applications for standing. The board should move through those. I can call them out, or the board, Mr. Chairman, you can call them out in any order you want. Ask those individuals to come up and indicate to you a full cast of the evidence as to why they would be an aggrieved party. That is a party that suffers special damages separate and distinct from the rest of the community.
Yeah, let's not start this off by stopping. And I think we need to vet each person with standing or their attorney with questions. I think let's just go ahead and do that at this point, if that's okay.
You want to call somebody forward?
Okay. So the first thing with the applicant, the property owner, local government have standing can participate fully in the hearing. So what we want to do at this point is we want to bring up each person and ask the person the question, who they are and why they have standing. Let me just state right up front, we're not going to have a bunch of redundant testimony that says, I believe this and I believe that. That can't, you need to be a qualified person, a subject matter expert, or somebody that has standing. We already know that the MRA has standing, as well as folks who are going to come up here and present. So let's do that first. So the first one, we're going to ask you to come up, and we're going to ask them to come up.
Chair, I'm happy to put that Bible down on the pedestal here. If that's
Yeah, why don't we do that?
We can go through them and swear them out one time.
Yeah, I tell you what, it might be easier, and for time, is let's call all of them up at one time. And that way, yeah.
Thank you. And Mr. Chair, if I can announce, the applications for standing that we have received are by Dr. and Mrs. Kimball. If they could come up and be sworn. Emmy Alexander Hancock, if she can come up and sworn. Kathy Dowd, if she can come up and be sworn. Ann Hayner, if she can come up and be sworn. And Brendan Hayner Slattery, if he can come up and sworn. The board will entertain those applications for standing after swearing in the order in which they were just called.
Mr. Chairman, my wife, Kathy Dowd, she couldn't be here, she's remote. So I don't know how y'all plan on handling that.
She can take the oath over Zoom, I believe.
She can take an oath over, she can affirm, over.
That's one point.
Thank you.
Okay, if you would, raise your right hand. Do you solemnly swear to affirm that the evidence you shall give to the board, this action shall be the truth, the whole truth, and nothing but the truth? If so, say I do. Thank you very much.
I do.
I'll call it come forward.
Dr. and Mrs. Kimball. It would be your opportunity to present to the board your reasons for standing.
My name is Millard Kimball. I live at 316 North Carolina Terrace, which is right next door to the Joneses. There'll be a lot of evidence today about noise, pollution, and cars and traffic. I'm not going to speak to those. I will speak to my individual. My house sits on North Carolina Terrace, but all my view is over Chestnut Lodge. My porch, my front living room, picture window, and all my bedrooms. So what's going to affect me when you clear cut 2 acres of land is my view is going to be changed. So I will see 2 acres of vacant land from the top. When they build the building, I will then see 20,000 square foot roof. That is going to change the value of my house. Second point, they're going to excavate for an underground garage. That means digging and probably blasting into rock. My house is 115 years old, rock pillars. Can anyone assure me that it won't affect the foundation of my house? I don't think you can. I also have a 15-foot retaining wall that keeps my house up, that backs up right to Georgia Terrace. Those are the facts. That's what I present to you.
Okay, questions from the board?
First question is, the home is owned by Sandra Kimball, trustee.
That's my wife.
So you two are both trustees of that entity, correct?
She is the trustee.
She's a trustee. My only thought, Mr. Chairman, as we go through this, I think they ought to be owners of the property or an officer in that various entity. Otherwise, it'll be crazy to figure out who's who. Is it ought to be an owner or an officer in that entity?
I'm sorry, but I've been very ill, and so I asked my husband to speak.
I'm sorry.
That's fine.
Hang in there. We're all,
I just thought as a board, because my point was earlier, if you are a member of Stony Creek Baptist Church, and Stony Creek Baptist Church owns a house here, that doesn't mean that as a member of that church, you would necessarily have standing in here. You'd have to be an officer in that entity to have standing.
Or staff member.
Or, well, usually it's an officer represents the corporation. That's true. Just so it's a legal representative from the company is all I advice on that.
so the point being that in order to have standing, you need to be an owner of the property that will be affected,
Or an unauthorized representative such as council,
or an LLC such as,
right? Or trusteeship, yeah, that's fine. I just want to get that out right off the bat.
okay, any other questions? Any notes from the attorney so far? How
No,
bad?
I think he was talking about I think he was indicating that he wanted to have the individuals with standing make sure that they testified about an ownership interest in the property. So
That's fine.
And so how the trust works, I don't know, I haven't seen the trust document, but the trustee, if it is Mrs. Kimball, you could take some additional testimony or evidence from her as to why she thinks she suffered special damages. Those damages are separate and distinct from the rest of the community. Then the board would vote on them
Okay.
individually.
And we'll add that to the list of people. We'll put it into the record that she's added.
Yes, yes.
Yes, ma'am. Yes.
Clarification, Mr. Chair. Could we also ask the role that each applicant is seeking to have in the proceedings? So are they wanting to be full parties, or are they merely wanting to present testimony?
Okay.
Say that again.
Yes, sir. If each applicant would just answer what role they seek to have in the proceedings, that would be very helpful. Thank you.
And again, we must ensure that we limit as much redundant testimony as we can. So this doesn't get too far. Okay, well, that's great. Is there any motion regarding whether these folks, which we're going to add, have standing?
And Mr. Chairman, before you take that motion, if you could just have one of the Kimballs testify as to their intent, whether if they're going to be a party with standing, do they intend to be represented by counsel, introduce witnesses, call expert witnesses, and cross-examine any witnesses offered by the application or by the applicant and the other parties with standing.
There we go. It may not be with this particular party withstanding, but I think each of the parties that have already been established to have standing have an opportunity to cross-examine or ask questions
That's
as
right.
well, just before a motion is made.
We agree to that, Mr. Chair.
Okay, now let's hear and then we'll do that. I mean, I think that's the fair thing. Okay. Is there a motion?
They were going to state something, I think.
Okay, I'm sorry. Go ahead.
Well, we will not be represented by an attorney. We represent ourselves, but we would like the ability to cross-examine witnesses. We would like to have that ability to do that.
Don't see any issue.
Well, so standing, right, is the damage that you suffer based on whether it's traffic noise, glare, odor, and the effect that it would have on the value of your property. They have to give us a forecast of the evidence of what specific facts are going to have what effect on their property. I understand that he says he has some issues with facts, but unless I would contend to the board, unless they would present sufficient evidence as to how that harms the value of their property, that they may not have made a sufficient showing of standing.
Sir, I would like for you to tell me why this would not affect the value of my property. I mean, this is a matter of opinion, but it's your opinion, it's my opinion, and it will affect my value.
Sir, I'm not giving an opinion on the value of your property at all. It is your burden as an individual seeking standing to prove to this board that you have damages separate and distinct from the rest of the community that will have some effect, injury to your property.
Okay, then I'd like to take the board to my house, take them to my porch, and let them see what we'll see. That's a fact.
Mr. Chair. Mr. Chair, go ahead. I'm happy to ask maybe a couple questions that might tease this out, or Mr. Morphus can as well, for the board's benefit to kind of get to the bottom of that. It might be of assistance to the board to hear that. If it's all right with you. So Mr. and Mrs. Kimball, my name's, forgive me, Dr. Kimball, I didn't mean any disrespect by that. I see here in your application that you note that you say diminished property value.
Yes.
Okay. Will you be providing any kind of evidence from an appraiser or some other expert about value?
No.
Okay. I see questions about noise pollution, light pollution, other pollution like that. Will you be offering any expert opinion testimony or have any experts retained? Okay. I think those would be the questions that I'd asked about that.
Just a few questions. Okay. As Mr. Golden can advise the board, it's not just demonstrating special damages, it's special damages distinct from the community at large. So Dr. and Mrs. Kimball have alleged, and I'm looking at their affidavit, increased human traffic on Georgia Terrace, noise pollution, light pollution, environmental damage from clear cutting trees, destroyed view, destruction of historic residential neighborhood to commercial. We would respectfully contend that, while we disagree with the statement, we would also contend that those are not damages distinct to the property if they exist at all. The only question that I would have, well, a few questions is, Dr. and Mrs. Kimball, do you live at the property year round?
No,
And where is your primary residence?
Melbourne, Florida.
And about how much of the year do you spend in Florida?
Depends on what year you pick.
That's a fair answer. Thank you, sir.
My concern here is with this, that now what we've got is nothing, you're not going to have the ability to listen to neighbors, what they feel unless they have a friend. I think that's really, and we're not going to, we don't have an attorney, we're not presenting evidence, so we want the ability to be able to question and speak when things come up.
Mr. Chair, if I can. Now. There we go. I know Mr. Morphus mentioned this to me earlier in the day, but I think the parties might be able to stipulate that the Dowds, or excuse me, Kimball's, could participate as witnesses in this matter if they would like to, just to address the concern that the board would not hear their concerns rather than being parties withstanding. And I just throw that out as an opportunity for the Kimballs.
I understand that, but my problem is my position of my house is unique from everyone else in my street. I'm 60 feet above Chestnut Lodge. I'm across the street from it. No one else in this community has the view I have. It's unique. And I present that as evidence because it's fact. So I do feel I have the ability to speak because no one else here will represent my position in this situation.
I think, Dr. Kimball, in order to have standing, you have to have data. And I think you can get data if you get a realtor to come up and take a look and say, you know, the view that you have now will be gone, and therefore your real estate value would be diminished because of the value. But we have to have data in order for you to have standing, which allows you to cross-examine. If we don't have the data, then you would be a witness without the ability to cross-examine. I think that's maybe the
I
distinction.
appreciate your answer. My problem with that is, and I could do that, I don't have time to do
I
it.
ask
And I
a
can do
question,
that
but
by, excuse me?
by being a witness to the council, by being a witness, does that afford them the same opportunity they would have had otherwise?
That's a great
My
question.
name is yeah, period. There's houses at 323 North Carolina Terrace. My intent is to provide testimony as the
Their
witness.
testimony,
Period.
we do not object to that. We object to having multiple parties with full rights of cross-examination and the whole gamut. But if
My
they
name
want to
is
tell you how they
Captain
work, we do not object to that.
Okay, Dr. and Mrs. Kimball, I think what we're hearing is you would normally come to a board of alderman commissioner meeting.
My intent today is to provide
Time to say
provide
something. This
testimony
is
as a witness.
unfortunately not, that's a different kind of
Previous
organization, judicial.
Speaker stated all concrete will be negatively
Definitions of roles.
affected by being built in the
Hearing
heart
how
of
both sides say
it will
you is that if you were a witness, you will have to be afforded the same opportunity that you have now to say something, we would be able to hear it, and that would be your easiest route.
Speak to it. We can hear it, but can we speak?
Can
to
we
it?
ask questions?
No.
So that's concerning to me that this is a community now that's going to limit us as residents, part-time residents, to speak to a situation that is changing our town.
Unfortunately, the law is very clear about what standing is. And so we need to kind of understand, like I said, this is an evidentiary hearing.
I understand that.
Right.
Why is my position different than the Jones's position? Because they have an attorney and I do not? We live next door to each other. What's the difference here between him having standing and we don't have standing?
I believe it's because they're presenting expert opinion. Both agree?
Yes.
Okay, you all gonna drag this out, make it ridiculous. Okay, we'll take witnesses and be fine. But it's-
Mr. Chair, if I could, just very briefly. Dr. Kimball and Mrs. Kimball, I just wanted to say, just very respectfully, just the difference in you and the Joneses and Kate Hayner, for example, is that they have, not that they've hired a lawyer, but that they've undertaken to hire a lawyer and also to devote resources to hiring expert witnesses to prove a case like you would have to in court. And so while I understand y'all's frustration and y'all's position, I just wanted y'all to hopefully try to explain that fundamental difference to y'all. So I hope that makes sense. Thank you.
Okay, any other questions? Yes, go ahead.
No, now would be the time for the board to, and we're just gonna do that.
Okay,
Make a motion on Dr. and Mrs. Kimball's application for standing.
is there a motion regarding that this applicant or this person has standing in this matter?
Make a motion, they do not have standing, but they are witnesses.
Second? Any comments, questions? Everybody who agrees, say aye.
All right.
All opposed? The ayes have it. Okay, who's the next one?
Miss Emmy Alexander Hancock.
My home is at 307 Georgia Terrace, which is directly across the street from the Walnut Lodge, which is next door to the proposed 40-room hotel. So clearly I'm affected by this project, but as has already been discussed, I do not have an attorney. I have not hired expert witnesses, so it appears that I will not be able to have standing, as I understand from the previous conversation. Is that correct?
We rule each one separately, so.
Obviously, the impact on my home is going to be dramatic in terms of the property value and the quality of life that I'm entitled to from the enjoyment of my property there. With this commercial structure across the street from my home, as opposed to what is now trees and a view of the mountain ridge, all of that will change.
Do you have interest in being a witness?
I do.
Ms. Hancock, do you have any reports from a Realtor? Have you talked to a Realtor?
I have not.
You have not. Okay.
I can do that. I have not.
Point of order, could we, if she did get information regarding the detriment to her house, could she be introduced as a party later on in these proceedings, or must she be determined now whether she has standing or not? This is a question.
Oh, this is what,
Yeah, it's a question.
so that would be up to the board, except we're dealing with the applications now.
Right.
And so we're determining party status. If she were to come back in, let's say, 2 weeks with her information, she would lose any and all opportunities to confront and cross-examine witnesses as they're being presented. So the board needs to do that now, so that she would have a full and fair opportunity to participate in the trial.
Even if we are probably going to roll over until next week, where there's more testimony and witnesses, if she came in next week with data, or could at that point, if she would like.
Except that the applicant may present 2 or 3 expert witnesses today who then will not come back next week. And Mrs. Hancock would lose the ability to confront and cross-examine those witnesses. It's a court, it is a quasi-judicial proceeding that this board has to follow, and following the rules are when we open up the evidentiary hearing, we know which parties have standing so that they can participate fully in the hearing.
And I assume that's out of fairness to both sides, both councils, to know everybody up front. Is that correct?
Well, I might have a different opinion, Mr. Goulden, on whether someone could walk in and wasn't today. Individuals can apply for standing even after this board has ruled in front of the Superior Court. So I do think that those cases could occur, but out of fairness, I do think it is important that we know who is in and who is out at the beginning.
Okay, and to the town, these are admittedly different procedures than we're all used to living in the town. Were these all made available? Could someone have easy access to this? Not that you necessarily would, but qualifying to be a speaker today, was that information available to town residents and all that through either a website or through some kind of procedure?
The application from the MRA for the special use permit was made available online on the website and sent all over the Montreat Minute. An application for individuals to fill out for standing was made available online and sent out through the Montreat Minute. So those were available to the public.
Okay, thank you very much.
And that was detailed in the letter of notice to properties within 250 feet of the site.
Okay.
Okay. Are there any more questions for this witness?
I have one.
Yes.
Are we to, it's dangerous to assume, are we to assume or not that the Kimballs are going to get professional help? Advice wise.
I probably will need professional help
Okay.
after this
I
hearing
think
is
they
over.
declined that early on.
All right. All right, thank you.
And so the motion,
Not motion yet.
no,
No.
I will say, I want to, I would like to give folks every opportunity who need to state the case. This is not against the individual person. It's about the law and what's required by the law.
So the motion is to deny standing, but to accept as witness.
Second.
All in favor, say aye.
Aye.
All opposed? Thank you, ma'am.
Thank you.
Next.
Ms. Kathy Dowd will have to do, I suspect, we will have to do some technological changes to have Ms. Dowd
Can you hear me?
with Zoom, I believe.
Can you hear me?
Here he comes. Okay,
Great. Can you hear me yet?
where is,
You see Ms. Dowd?
no?
Yes.
I saw him running. It looked like he was,
I did too, I thought, yes.
She is on Zoom. She's just not.
Visible.
projecting.
Okay, thank you, Mr. Morpheus.
can we maybe go to the next person and then come back to this person? Would that be?
Yes. Ann Hanger.
And here, 319 Silver Drive is property that I'm part owner of. Closest property to proposed construction. As has been mentioned, my sister Kate Wiener has counsel, Jamie Whitlock. They will be presenting evidence. Various issues that I have outlined in my request for standing, which will speak to our property. I am not a client of Jamie Whitlock. He's not representing me specifically, but I am one of the owners of the house, so the evidence that's presented will apply to my case. I have outlined specific special damages that our property will suffer, and for that reason, I have the right to have standing in this case, including full standing for full participation, cross-examining if necessary, appeal if necessary, the other elements that go with having standing. I don't plan to present additional evidence myself, and I'm certainly not planning on repeating things that have already been said. But if there is something that I feel I need to ask or need to participate in, I would have the right to do that as having standing as an owner.
In our layperson's language, the School of Government on these issues tend to say that if you can combine and versus having redundant testimony and so forth, it would be better to do that.
I completely agree. And I am not, as I said, I'm not planning to repeat any testimony. It's very possible I won't need to make any particular statements. It would only be if I feel something has been left out that hasn't been brought up that I need to ask a question about. I am planning on relying primarily on the testimony and the presentation that others are making, but having legal standing is something different than whether I'm presenting a case. Legal standing is something that I have the right to as an owner of this property. I've made credible allegations, which is what the requirement of the law is. I have to make a credible allegation of special damages. And I've made that credible allegation, and I've said that you will hear evidence to support those credible allegations. And for that reason, I have the right to have standing. And I absolutely do not plan to repeat evidence that's been presented, but having the standing is a separate issue. It's a legal right that I have.
Sure. May I ask one question if I
Sure.
understand you correctly? You're not repeating, but you are bringing forward expert opinion.
I'm relying on the expert opinion that others will be presenting.
So they'll be presenting, somebody will be presenting expert opinion,
Yes,
which you wouldn't be adding to.
at this point, I do not have any experts that I've retained separately. I'm not presenting a different case, for example. I don't have a different attorney. I would be relying on that, but I just have the legal right to have standing as one of the owners of the property. Not to, in other words, I don't expect it to add anything to the length of the case.
Thank you, Ms. Hayner.
You don't want to testify, but you want the ability to question.
Yes, I want the ability to have full legal standing for whatever the rights are. That includes the right to make a statement if that's the appropriate time, to ask questions, to raise an objection, or to file an appeal, for example. All of those are rights that only belong to parties with standing. And because of that, I would like to be a party with full legal standing
even though, as I said, I don't have a case that I'm planning to present at the moment.
Members of the board, I think I want to thank Ms. Hayner for articulating the fact that she recognizes that we want to avoid repetition. And with that understanding in place, again, we have no objection because she is also on property.
Right. So in light of that, I'd like to move that we approve her as per adopt her or whatever the terminology is as a person of standing.
Is there a second?
Second.
All in favor, say aye. All opposed? Ayes have it. Thank you. Next.
We have Kathy Dowd ready to appear by Zoom yet?
Yes, I'm here. Can you hear me?
Yes, we can.
Excellent. Are you ready for me to go?
Ms. Dowd, if we can just, we're trying to get you on video,
Oh, boy.
but we can certainly hear you. There you are. Good afternoon.
Good afternoon. Shall I start?
Yes, ma'am. Go ahead.
My name is Kathy Dowd. My sisters and I own the houses at 325 and 327 North Carolina Terrace. My intent today is to provide testimony as a witness. As the first speaker indicated, there will be much discussion about how all of Montreat will be negatively affected by this hotel being built in the heart of Montreat. It will affect property values, the environment, traffic, parking, and noise pollution. So how does it affect me? It will shatter the peace and enjoyment of our property, which I am considering retiring to in the future. And I have devoted financial resources to oppose this hotel. Thank you very much.
Mr. Chairman, I just heard she wanted to be a witness, not a person withstanding. Yeah.
That's what I heard. She said witness not standing. Should we double check with her?
Let's just ask that a question again.
Yes, I would like to provide testimony as a witness.
Okay. Somebody can move.
I move that we accept Kathy Dowd as a witness, not withstanding.
Okay, we have a motion and a second. All in favor, say aye.
Aye.
All opposed? Aye.
Thank you, Kathy.
Thank you.
Oh, yeah.
Thank you. Yeah, if we could get Ms. Dowd, are you still available? Can you still hear me?
Yes,
Would you, not that you offered any testimony, but I believe you did offer a little bit of facts on how it's going to affect your property. Would you care to affirm your testimony
what does that mean?
that you would affirm that the testimony you gave is truthful?
Yes, it will affect my property values.
And do you affirm that that testimony that you gave prior to that statement is truthful to the best of your knowledge?
Yes.
Thank you. The last applicant with standing was Mr. Brendan Hayner Slater.
My name is Brendan Hayner Slater. I'm in a very similar situation to Ann Hayner. I'm part of the family at 319 Assembly
Drive. And I expect that we will hear evidence today specifically relating to the special damages that I will suffer at this home. And I am entirely on the same page of not wishing to elicit any repetitive evidence, but I would like to request to have the right of standing so that if further evidence needs to be presented, I have the ability to examine witnesses or testify if need be, or have the right of appeal.
Are you an owner of title for the property?
I am not on the deed, no.
Do you have specific evidence that will be brought forward that won't be brought forward by the others?
I certainly can't say exactly what evidence other people will be presenting, but I have investigated specific evidence that I am prepared to examine witnesses on and elicit if it is not repetitive, if it is needed. I would like to be able to exercise that right of standing to elicit that evidence.
Mr. Chairman, I move that he does not have standing because I do prefer to be a property owner.
One of the things that the School of Government recommends or suggests is that you get together and you talk together and you present a cohesive case. That's just a suggestion. Any other opinions? Law opinions here?
I mean, I think Mr. Slattery indicated that he doesn't have an ownership interest in the property.
I made a motion.
Okay, motion's been made. Do I hear a second?
Second.
All in favor, say aye. All opposed?
Is that a motion to deny?
That's a
Yes.
motion to deny, correct?
Yes.
Okay, any other questions, attorneys, anything else before we move forward? Before we go too far, we understand there's some agreements about how we're going to present today and what we're going to present today, and then what we will present later. Can you kind of tell us what you guys came up with? Special inter-attorney conversations?
Hopefully for your benefit.
Yeah.
I think our stipulation was that the MRA was going to put on their case tonight. I think we're all anticipating that will not take the whole night, hoping that's the case. But if that takes the full 5 hours, great. If less than that, we'll be done at that point, and then we would be presenting our case next Thursday. With the one addition that I think there's one witness for the MRA that needs to present next week just due to a scheduling situation, and we were happy to accommodate that witness to come next week to do that.
This may be a distinction without a difference. That's correct. We have one witness who needs to testify next week, and we are fine with the Jones and Hainers presenting their witnesses next week. Given that it's now 5 o'clock, I hope we won't be here presenting our witnesses for 4 hours, but if we're not able to present all of our witnesses tonight, we do want to have the ability to carry over to next week.
Absolutely.
Otherwise, Mr. Norris.
And we wouldn't object to that if we don't get through them all, obviously.
Okay. Well, that brings up a good point. I'd like to do a little housekeeping on what process is and what we're going to do. We're going to take a break, a 15-minute break every hour and a half. So that's our plan now. If there's an emergency on the board, I think we can make a little bit determination, like got to go to the bathroom or whatever. So that's what we're going to do. As we take breaks and as we go from week to week, hopefully we don't go too long, but if we do, there's a special thing that we all understand being on the Board of Adjustment. And that's, we're here to not talk outside of this case. We don't talk to each other. We don't talk to others. It's like being sequestered almost. We are not going to continue either after a break or after the weeks. We will continue that process. And I must remind everybody, you cannot talk about the facts of the case. It's important on either side, not with your neighbors, not with your mother, not with I'm talking about board members. Families can talk, but board members, we gotta be quiet. Also, the thing that we want to come up and state very clearly, has there been anyone on the board who have had outside communications with others discussing this case and the facts of this case.
Yes.
Okay, can you,
I received a phone call from Mr. Powell Jones. I believe it was in February. This was before I knew anything about the lodge itself. He was calling me as a neighbor to tell me that this was happening. Very shortly into the conversation, I realized that it may come up in front of the Board of Adjustments. At that point, I said, I'm a member. I shouldn't be talking to you, but you go onto the website. There are certain questions that, if this comes up, that you would have to present and have to answer. And at that point, he was very nice and said, thank you very much. And we terminated the call. So that's my interaction.
thanks.
Mr. Chairman, I had somebody knock on my door and say, I'd like to come in and talk to you about the Board of Adjustment. And I said, get lost. And they got lost.
Can you be a little clearer?
Nope.
Others?
I have requested a site visit, and after the third or fourth inquiry, I was told that I could not visit the site. I was told there were cameras there and they'd know that I went.
And who were you told by?
I don't think I'll divulge that. But that was that's my story.
Go ahead.
I did not go near the site,
Mr. Chair,
even though I could.
we would just note that the board is allowed to do a site visit under the statutes if it should so choose, but individual visits are, my guess is staff just wanted to coordinate that if that was something that was going to happen versus individual members.
Yeah, it's very clear that we can visit the site and actually should visit the site. Other questions?
Yeah, I'll just, Mr. Chairman, if the board members are done indicating their ex parte communications that they may or may not have had, I just have a few questions for the board. This would be for all board members. Do any board members have a fixed opinion, one way or the other, about this application that is not susceptible to change? Can everyone be fair and impartial and base your decision on the evidence presented throughout the hearing?
Yes.
Does anybody have a close financial interest in the outcome of this hearing such that you would benefit if it's either approved or denied? And does anybody have a close familial or a family relationship with anybody, the applicants and or the three parties that have been approved for standing? Anybody have a close family relationship?
No.
Each of you can be fair and impartial regardless of what you've heard or been told, and you can make a ruling based on the facts.
Yes.
If Mr. Morfis or Mr. Noor or Mr. Whitlock have any additional questions. And then I guess my question would be to each one of the parties withstanding, do you all approve the board as constituted up here? Do you have any objection?
Does any party have an objection concerning the impartiality of this panel?
Not based on the information we've received at this time, no.
We would respond in the same, no objection based on the information we've received.
Same response, Mr. Chairman. No objection based on the information we've received. Thank you.
Okay. So I guess we move forward, and what we'd like to do now is open the evidentiary phase of the hearing. We start that with a presentation by the staff to provide a history of the case.
everyone hear me?
I'm sorry.
Need to be-
You have a Bible there? And do you solemnly swear or affirm that the evidence you shall give to the board is this action shall be the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
I heard that.
Okay. I've pulled this right up to my level. I'm 6'4", so I will lower it for the next person. So if everyone can hear me clearly. Okay, so just for a reintroduction for the room and the board, I'm Scott Adams. I'm the zoning administrator. And I believe in a moment we'll have a presentation come up on screen, and I'll just be glad to walk through it. Didn't quite know that would be right above me like that, but that's all right. So we, just as a brief overview, this is a special use permit request for a property at 309 Collegiate Circle. It is for a 40-room hotel and related site modifications. And this is before the Board of Adjustment today, October 21st. Next slide, please. So again, the site, it's at 309 Collegiate Drive. The proposed project is to demolish 3 existing buildings and replace it with one 40-room hotel that is hotel by definition of the Montreat zoning ordinance. The hotel within the institutional residential zoning district is listed as a special use. Thus, it requires a special use permit from the Board of Adjustment. Just a quick overview of some of the standards that are being considered as part of this application. Again, the proposed use is a hotel per the definition within the Montreat zoning ordinance. The minimum lot size is 10,000 square feet for any other use other than residential uses within this zoning district. This site is just over 2 acres. The minimum lot width is 100 feet for, again, any other use or any other use other than residential. The width of this property is just over 400 feet. Setbacks, they're 25 feet in the front, 12 feet on sides for interior lots. That's 17.5 feet if you're on a corner lot, but this is an interior lot. And again, 25 feet on the rear. And of course, if you've got double frontage, which this property does, meaning that it has frontage along Georgia Terrace and Assembly Drive, that the 25-foot setbacks apply on either street face. The height limit is 40 feet, and the proposed height of the tallest roof gable on a peak is 30 feet 8 inches. And screening requirements either require a fence or a 6-foot high evergreen set of vegetation, and the proposal is to have a 6-foot evergreen buffer. Next slide, please. This is a brief overview of the site in terms of proposed, or I'm sorry, existing parking. As you can see, the buildings in sort of light, just dark red on the right, if you're looking at the screen, are the buildings proposed for removal, in addition to a gazebo, or it's an open, I'll call it a gazebo on the left there in the middle of the site. The existing spaces, there are 41 spaces on site. The removal of the buildings would result in the net loss of 20 rooms. So the proposal of a 40-room new building, that would be a net addition of 20 spaces. So the 41 existing spaces plus the required 20 new spaces plus 1 space for a manager would come to 62 total spaces. Next slide, please. This is the this is one of 2 sets of proposed parking arrangements within the application. The set number here is 62 spaces based on the methodology that I just walked through of the removal of the existing buildings, the addition of a new building,
And of course, the provision of one parking space for a site manager. Next slide, please. This is a brief overview of the proposed circulation on site as I have understood it, and as the reviewing staff member. The white arrows are the current one-way direction from west to east along Collegiate Circle. The blue arrows represent vehicular directions, and the yellow arrows at center and coming from the north side of the site represent pedestrian flows. As you'll see here, again, the current one-way direction of Collegiate Circle runs from the post office on the east, or I'm sorry, on the west, toward Assembly Drive on the east. I have a staff recommendation to consider as part of this application. Next slide. The consideration, just from a general circulation and wayfinding standpoint, would be if this project was approved to reverse the one-way direction of Collegiate Circle so that it is entry only from Assembly Drive. This would allow a right-in, right-out movement from the central proposed parking area. There's already a current parking area there, and it would basically be modified for effectively a traffic circle or roundabout function, just as it's shown there with the arrows moving through. So that's it's a potential recommendation as you consider this overall project. Next slide, please. In terms of considerations of trees and landscaping, there are 60 total trees proposed for removal on the site. The majority of them are on the actual proposed building footprint, basically toward the center and right of the site. On the left, there are some considerations in the zoning ordinance. It's Article 9 landscaping. A full landscape plan would be required to be submitted if the special use permit was approved for the project as part of an ongoing administrative review for all relevant standards. Also, just make a note that not less than 5 and not more than 40% can be required for new landscaping on a given site. And there is a provision, it's section 904, talking about existing flora and fauna, or existing flora. Essentially, it's stating that any development on a site should seek to preserve as much flora on site as feasibly possible, but it does recognize that you cannot do that in the direct footprint of a building or a roadway.
Scott, could I ask a quick question? Is it possible at this point? So your previous one showed the trees and so forth on the right-hand side. This one shows no such thing. Is there a difference or?
So actually, the call out on the bottom of the screen does note the removal of a tree within the right-of-way, and I think basically it's a little hard to see this far away on the screen, but basically, a X over a tree is a proposed tree removal. So I guess basic to answer your question, to the left or west of the site, where Reynolds and Hickory Lodge buildings are, there's no proposed tree removals on that side of the property. I'm sorry?
The other side, next. So you went to the left. I'm going all the way to the right now.
Okay, I'm sorry.
The previous screen showed a bunch of trees there, and now I don't see those here.
Right. Well, there are two different renderings. Okay. So this is much more of a site plan schematic, and the other one was more of an illustrative. So,
okay, thanks.
And you'll see many more of those as the presentations go on. Go to the next slide, please. So this is an illustrative that was submitted by the applicant. I'm simply using it as an exhibit markup. So the information that I've received to date, the previous slide noted the removal of 60 trees on site, and this exhibit proposes, or at least notes, the addition of 20 trees. So 60 with the addition of 20, that's a net loss of 40 trees. With a pollinator meadow along the south side of the property and again, an evergreen buffer that's adjacent to 319 Assembly Drive. Next slide, please. So regarding erosion and sediment control, the town itself has no independent ordinance on erosion sediment control. It adheres to the Buncombe County standard for erosion sediment control, which this site will be subject to since it is more than 1 acre of proposed disturbance. That's the county threshold for erosion sediment control review. Taking a look at the initial submission in the packet and the application packet, silt fences have been shown. That's basically the dark line running along the south and east side of the property. A temporary gravel construction entrance is shown, that's highlighted there in yellow in the center of the slide. And in terms of proposed disturbed area, that's basically the disturbed area is, you know, any blade of dirt turned over, any bit of vegetation removed. It's just over an acre, an acre and a half within the property. That's just over 78% of the property. And the total disturbed area would come to an even 2 acres. Next slide, please. So that would be if this project was approved and moved forward. And so that the erosion sediment control considerations are best described as in construction considerations. Post-construction stormwater, the stormwater that would result from any given site on a long-term basis is illustrated here, and this would be subject to the town's stormwater ordinance and reviewed by county staff for the county ordinance as well. The applicant to date, to my understanding, has proposed to meet the town's standard, which is more stringent than the county standard, and that's illustrated here with a set of new stormwater pipes, a stormwater swale along the eastern property boundary with 319 Assembly Drive, and an underground set of detention tanks that's highlighted basically in the middle of the slide there on the south side of the proposed building. And that would have that's been proposed to have a capacity of 4,285 cubic feet, which is just over 32,000 gallons of stormwater. In terms of impervious surface, that's a surface like a roof or concrete or a driveway, something that it can't readily absorb rainwater. The existing impervious area is just under 1 acre. The proposed impervious area would be just over 1 acre. So the addition would be 0.22 acres or 97, sorry, I can't quite see that, 90 square feet. Next slide, please. Lastly, as the project relates to the town's 2008 comprehensive plan, it's actually within 2 areas that are identified in the comprehensive plan. That's Town Center 1, and the language is there as it's describing Town Center 1. It mentions several things relating to the MRA, also to the general concept of change. It mentions there. Also, I'll just note on the slide here, the kind of the dotted line that you're seeing at the center, highlighted with a yellow rectangle. That is the Assembly Drive area. It's basically illustrated as an overlay area within the comprehensive plan. And the language that describes that area, again, recognizes both a mix of land uses, not just exclusively residential use, and also the possibility and likelihood of some degree of change over time. Next slide, please. With that, I'm glad to take any questions. Board Matt.
Can you differentiate for me the town center versus the IR district?
So the IR district it's a specific zoning district with very specific dimensional standards, height limits, what have you. The town center designation within the comprehensive plan is a more general land use policy. So the language that's contained within that would guide and influence a decision in a given zoning district, but there's not necessarily a direct correlation between the two. Oftentimes, if you've got a land use policy, generally you're trying to set a land use policy through your comprehensive plan. That's your 10,000-foot view. And as you are updating and changing zoning over time, you're trying to align your zoning with that policy for say a 10-foot or a 100-foot view. But to my knowledge, the IR zoning district has not been modified or was not created in relation to this specific land use policy in the comprehensive plan.
I have a question about parking.
Sure.
There were two proposals in our packet. One was for 61 and
62 and 71.
62 and 71. I know the minimum is, from way of reading it, the minimum would be 61. So
62, 61 plus the manager.
Right. So the total number of beds, including the existing or the remaining 3 lodges, would be 70 rooms plus 1 for on-site manager.
Mm-hmm.
What happens when you have something, a special event happening, caterers coming, maintenance coming? And we're assuming, I know this is probably rare, but full capacity, every parking space is used. What happens to all the caterers and where do they park?
Sure.
I guess it's my
So
question.
I'll speak briefly to a part of your question. I would advise that the other half would probably be best answered by the applicant. Just to clarify, the parking requirement is it is a stated minimum parking requirement. So an individual property owner only has to meet that minimum standard if they saw it fit within either their expected visitors or business model, what have you. That's up to an individual owner, but the standard is a minimum standard.
Scott, just to set the table a little bit, so from my understanding, in your presentation, you'd implied this is all consistent with the long-term plan that was the comprehensive plan, land use plan that was adopted by the town. Is that correct?
I'm sorry, you were asking?
The future plan or the land use plan that was adopted by the town of Montreat.
Yes.
This is consistent with that thing so far?
There are
The
elements
use-
of that, but sorry.
Yeah, I'm looking for, I expect you to come back on that. My question is the staff saying it's consistent with the comprehensive plan?
I'm not stating it if it's
Okay.
consistent or inconsistent. Sorry.
That's what I wanted to say, so you knew where we were going on that one. All right, secondly, any land use planning that was done, where we defined town center and all of that, is that a term you came up with now, or is it a previous term given to that area?
No, that is the term used in the comprehensive plan.
In the comprehensive plan, and when was that plan? I don't believe any of us were here then, or most
It
of us weren't.
was adopted in 2008.
And as our understanding, it was a community effort. It was conducted at a public hearing, all of that, and it was done at a time where there wasn't an issue presented, but it was done at a time where there was collaboration and discussion.
That's my understanding of the adoption of
Anybody have
this.
testimony? Alex, do you have words otherwise to that? Okay.
To your question, we're going to be presenting a fair amount of testimony with our witnesses to exactly that point, sir.
Okay, that's fine. Perfect. All right. Thank you very much.
Okay, anything else? All right, thank you.
Mr. Chair, we would have some questions, I think, for the witness as well. Mr. Whitlock may want to go first. Sure.
Josh, if I could get you to tee up my presentation, please, sir.
Chair, I'd also note it's 5:26. And I know you said you want.
You're not going to be over 4 minutes, right?
I have no idea.
I will not myself individually be under 4 minutes. Mr.
Okay,
Chair.
let's take a 15-minute break. Remind everybody that we are under zip it.
I'm getting ready to send this to you, Mark.
Huh?
I was getting ready to pass this to you.
Yeah, sorry.
We got to take off this part. That's great. Good job.
Give everybody a chance to get back in. We'd like to start, like to be on time. Okay. Continuing the hearing, one more housekeeping issue. If you come up and speak to that mic, if you don't mind, we'd like you to, we can't hear very well, so if you could, and you don't have to get right up and speak right into the mic. Cleared it with our resident geek up there. He said you could go back a little bit, but if you would,
Name calling already.
So is there a suggested distance from the mic?
distance from the mic, not very far. Not 6 feet, but,
Gotcha.
and that's to prevent others who come up later. In
Sure.
case, you know,
So don't talk like this. Don't talk like this.
we'll tell you.
Talk right here.
You're good. Okay, I believe it's.
Thank you, Mr. Chair.
Council.
Josh, if I could get those slides up, please, sir. Mr. Adams, thank you for your staff report and for your presentation. Just had a few questions for you.
All right.
I'm looking at page 3 of your, I believe it's the September 15th version of your staff report. Just as a housekeeping matter, am I correct to understand there's been an updated version of this report since that time?
No, there is not.
There is not. Okay. On page 3, at the summary, at the first bullet point, you note that the project proposes to demolish 3 existing lodges containing 20 rooms or 10,650 square feet of space, and then demolish another outdoor structure, and then construct a new lodge building containing 40 rooms, 29,000 square feet of space. Do you know, is that 29,000 square feet, is that total square footage of the proposed hotel, or is that conditioned square footage?
I'll let the applicant answer that. I'm not aware. I believe I was simply listing what was in the application.
Sure. Let me, if I can show you what's up on the screen right there. This is, and I'll represent to you, this is a schematic off of the MRA website. And do you see at the top where it says gross conditioned square footage, 29,000? And then it's also got the lower level square footage, garage, laundry, and that's an additional 11,790.
Yes, I see that.
So would that be 40,790 square feet total?
I don't know. The parking garages are generally considered to not be conditioned space.
I understand. I'm talking total square footage, not conditioned square footage.
I'd have to let the applicant clarify the actual total square footage. I was simply citing what was in the application.
Understood, understood. And just if we can try and give the board a little bit of context of the size of this structure. Wanted to show you this, and I'll represent to you, this is the Buncombe County assessment property tax record for the Hainer property next door. And it shows the Hainer property is 11, or the Hainer residence, excuse me, is 1,170 square feet, correct?
That's what I'm seeing on the screen.
Okay. Do you have any reason to dispute that?
Nope.
Okay. And then we had already discussed in the staff report, you had noted that the 3 lodges contain 10,650 square feet of space. Do you know what portion of that was the Galax House square footage?
I do not.
So let me show you here. There we see a picture of the Hayner residence on the right, the Galax house on the left, and again on the right, I've got the Buncombe County tax information for the Galax house, which shows it having 3,125 square feet. Does that sound accurate to you?
That's what I'm seeing on the screen.
Okay. So if, just to put this into perspective for the board, looking at the proposed MRA hotel size comparisons at 29,000 square feet, if we want to go with that number, it's 25 times the size of the Hayner residence. Does that seem accurate to you at 1,170 square feet?
Yes, that sounds correct.
And then for the Galax house, again, if we'll go with the applications number right now, 29,000 square feet. That's about 9 times the size of the Galax house, which sits in the location, the approximate location of where at least the eastern half of the proposed hotel would sit, correct?
You're asking me?
Yes.
Yes, that these numbers appear to be mathematically correct.
Can I ask a question of council?
Yes, sir.
You are establishing kind of order of magnitude, not precision, is that correct?
Yes, sir.
And you're comparing a commercial use to a residential, to a decent residential use, is that correct?
That's correct.
Okay.
That's correct, because that's what's proposed here is
Right.
putting a
I just
commercial
want to
use.
clarify that we're, yeah.
Understood, understood. And so, and Scott, even just, or excuse me, Mr. Adams, just based on the square footage listed here in the summary of the staff report, that's a tripling of square footage on the property, correct? Or based on what is being demolished as compared to what is proposed to be built, correct?
Yes, if you are comparing 10,650 to 29,000.
It's an approximate tripling, correct?
Almost.
Okay, thank you. Going over to page 4, you do have your staff report.
Yes.
Thank you. Thank you. In front of you. I wanted to ask you, you've got there the figure showing the properties that were within 250 feet requiring public notice under North Carolina law, correct?
That's the requirement under the local ordinance. That's correct.
Okay. And how many residential properties were there within 250 feet?
I don't know.
Okay. Do you know how many properties there were?
I don't know. I believe if you look at the mailing list, that's the corresponding list that was sent out.
Council, one more question. Are you differentiating between corporate owned or its use? Its ownership is a
Use.
use.
Use. So Mr. Adams, as we stand here today, you don't know how many residential properties were within 250 feet?
I do not.
Okay.
The notice requirement is only for properties within 250 feet.
Understood. Looking over on page 5 of the staff report, and towards the bottom of page 5, you note the side setback.
Yes.
And so what I put up here on the screen on the left, that is from the MRA's application. If you recognize that, and on the right is a picture with the Hayner residence on the right and the Galax house on the left.
Okay.
Does that appear to be accurate to you?
Yes, I see that.
Okay. And so there's a 20.5-foot setback on the eastern side between the Hayner property line and the proposed hotel, correct?
That's what's stated in the application.
And what we're seeing over there on the right is about a 13.5 foot between the Hayner property line and the Galax house currently, correct?
I haven't measured it. I can't say.
So based on what's in the application anyway.
Yes, based on what's in the application.
Okay. And so essentially, while we're tripling the square footage, the hotel would just be moved over approximately 7 feet from the Hayner residence, correct?
I'm sorry, what are you asking?
So we established earlier that this is an approximate tripling of square footage being proposed, the hotel versus the Galax, or the 3 lodges being demolished, correct?
The proposed building per the application is 20.5 feet from the property line.
Okay. And I was going back to the square footage. So let me ask you this question. Do you know of any other building of the size of the proposed hotel in Montreat that is this close to a residential property?
I don't know.
Gentlemen, before we get to, I'd like to ask that we get answers to that. We could be placed in the record. Let's get real answers versus I'm not sure, I'm not.
That would certainly have been my preferred answer, Mr. Chairman.
By our count, do you think the number is 21 residential uses in the 250? Is that what the number you came up with, 21 residential homes?
I did not have the number. I anticipated that Mr. Adams would, given that he had sent out the notice.
Okay, he
But
did give us a list, but you probably saw, did you see this list?
I did.
Okay,
I appreciate that clarification there.
and I excluded the MRA properties from that list, and I counted 21. It's there on my little map here I've been keeping.
Okay,
Does that sound reasonable to you?
that does.
Okay.
That does.
Well, and Mr. Chairman, I just, for the purpose of the record, making sure that we're getting evidence from the witnesses into the record, I think is important. And that's why some of these questions are being asked, is to allow for that to happen.
Okay.
Board members naturally have information by living in the town, but predominantly the evidence needs to come from the witnesses. I think this is a perfect example of just trying to clarify something, but I think that's why Mr. Whitlock's asking some of the questions is to get that from the witnesses.
I don't mind that. What I do mind is trying to draw conclusions by asking questions when we maybe don't know all the information.
And I'm just trying to be careful that, because we're not allowed to cross-examine the board members necessarily.
Gotcha.
So if information comes from you all, that puts us at a little bit of a disadvantage because we're not allowed to go through that same exercise.
Which was my question to council on, do you agree 21 is a reasonable number?
Let's just answer the question. Let's supply the information, Scott, if you don't mind, supply the information, then there won't be any question.
Thank you, Mr. Chairman. Scott, if we move over to page 15, look at the landscaping and trees. And I believe this goes over also onto page 16. At the 3rd bullet point, it noted planting a net total of 20 new trees in the staff report, correct?
Yes, that is correct.
Okay, and I believe when you made your presentation earlier, you referenced a net loss of 40 trees. Is that accurate?
That was a misstatement. The correct number is 60 removed, 80 planted, net 20.
So it's your testimony that what is in the staff report, the September 15th, 2021 staff report is accurate. What was in your presentation earlier, the net loss of 40 trees is not accurate.
Correct.
Okay.
Yes.
Did staff perform any type of assessment of the age or condition of any of these 60 trees to be removed?
No.
And in terms of the net total of the 20 new trees, in contrast to those being cut down, Those would be saplings, correct?
I would have to consult the landscape ordinance once, or if or once an application came in for a detailed landscape plan.
So you do not have a detailed landscaping plan at this point?
Correct.
Okay. If we move on over to page 17, which is erosion and sediment control. You reference a September 1st, 2021 from the project's engineer of record, John Kinnaird from Brooks Engineering. Is that correct?
Yes, I mentioned a letter from Mr. Kinnaird.
And then also, I believe you referenced that letter over on the bottom of page 18 as it pertains to post-construction stormwater control. You referenced that same letter, correct?
Yes, correct.
Chairman, this is the September 1st, 2021 letter from Brooks Engineering to Mr. Adams. I'm gonna get 8 copies, one for council, one for the board. Yes. And I may be running short on copies. You have one of those. Thank you. Do you recognize this letter, Mr. Adams?
Yes, I do.
Okay. And this letter was not part of the initial application submitted. Is that accurate?
That's correct.
Okay. And is it also accurate? You requested different information from the applicant, the MRA, with regard to erosion and sedimentation control and stormwater compliance, and this is what you received in response. Correct?
This is the letter I received. Yes.
But this letter is not evidence of compliance, is it?
It's not evidence of compliance, but it's not required at this time.
What purpose did this letter send in your review of the application?
It serves the purpose of documenting that the engineer of record has acknowledged that they will meet all relevant erosion sediment control and stormwater standards at a later date upon submission of a full permit for administrative review pending approval of or denial of a special use permit.
Okay. Is this a sworn statement?
Yes.
This wasn't?
I'm sorry, the letter?
Correct.
I can't speak to whether it's a sworn or not sworn letter.
It's not a sworn statement, is it?
I don't know, I'm not an attorney.
Maybe help him understand what a sworn testimony is.
Is there any statements that are testified to under oath? Is this an affidavit?
I don't see the word affidavit anywhere on here.
Okay. You understand, this is this board's only opportunity to decide whether or not this project is going to comply with erosion and sedimentation control, whether it be the town or Buncombe County, and stormwater requirements, correct?
My understanding is that the board is considering criteria for the special use permit.
Okay. And you understand that the special use criteria also include an affirmative finding on development standards which includes stormwater drainage and erosion and sedimentation control.
Mr. Chairman, I have a question as a board member. Is this true evidence or not evidence? This is an evidentiary hearing.
Board member, I'm not sure I understood your question, but we'll have to let the applicant present his case, the opposition present their case, and when they have an opportunity to cross-examine, we need to let them cross-examine. The board can determine what weight, if any, they give to the answers that are elicited by any of the questions.
I'll make one very short statement in that the information that I have received to date from Buncombe County erosion sediment control staff and stormwater staff is that this information was sufficient.
I'm going to object to this as hearsay and ask that it be stricken from the record. Mr. Chairman.
Sustained.
And Mr. Chairman, if I could, to answer the gentleman's question, Mr. John Kinnaird is going to be participating by Zoom. So he is the gentleman who wrote the September 1 letter, and we will at the appropriate time seek to have it admitted into evidence upon proper authentication by an expert.
Perfect, thank you.
And that's fine, Mr. Chairman, but the purpose of my questioning is the nature of the zoning administrator's reliance on a letter saying we, the MRA, will in the future comply with erosion and sedimentation control and stormwater requirements, instead of submitting documentation or evidence showing said compliance, so that this board can make the affirmative or adverse findings that it needs to make. So that there's a difference.
And who would be presenting that?
Well, Mr. Chairman, again, as I pointed out, Mr. Adams stated in his staff report, both in regards to erosion and sedimentation control and stormwater, that the majority of the staff findings were additionally, this letter was submitted. Well, what does this letter prove? It's a statement that they will comply in the future.
How can you prove compliance when something isn't built?
Because these are erosion and sedimentation control are things that have to be done during the project to ensure no sediment gets onto adjoining properties.
Sure.
Gets into Flat Creek, which I believe is about 70 feet away from where they're proposing to put their
I'm going to
stormwater.
object. At this point, opposing counsel is presenting his own expert testimony. If you would like to question Mr. Adams, that's great.
Counsel, a board member asked me a question and I was responding.
And what I would just advise the board is not counsel, based upon what they're asking, let them ask their questions, and the board can do with it what they would like.
And if this is being submitted, it can be submitted, but we can either disregard it or not.
Yeah, and it hasn't been submitted, it has been submitted into
Yes.
the evidence, it's just handed up as an exhibit that was cross-examined. Mr. Adams.
Right.
Just as a clarification, I wouldn't want the board members to be left with the impression, I don't think Mr. Goulden's suggesting that you can't ask us questions. You can. I think he's just suggesting get it from the witnesses.
You can ask the question. I don't want you to engage in a banter back and forth where you're asking questions and then they're asking questions. We need to let the witnesses testify. Counsel's not sworn in, none of the board members are sworn in. Let's hear the evidence from the witness who had it.
Mr. Chair, I'll move on in the sake of keeping this going.
Okay. Other questions?
I do, just a few more. Mr. Adams, also on going over to page 19, we're still in the post-construction stormwater control. It notes the need for a stormwater control permit under section 303 of the ordinance, correct?
That's correct, yes.
Okay. And as we sit here today, no such permit has been issued to the MRA, right?
Correct, yes.
Okay. And then one final question, and I believe you might have already answered this in response to a question from the board, so I apologize. In regards to any staff quote unquote findings on the comprehensive plan, Staff did not do any type of independent review or analysis of consistency or conformity with the comprehensive plan, did it?
I'm sorry, you're asking if staff did an analysis of the comprehensive plan?
Did staff do any independent review or analysis of consistency or conformity of the MRA application with the comprehensive plan?
Staff read the language contained in the comprehensive plan against the language of the proposal and deemed it consistent.
Those are all my questions for this witness. Thank you.
Thank you. Any more questions?
One housekeeping matter. Mr. Golden, I would ask to mark the September 1st, 2021 Brooks Engineering letter to Mr. Adams as an exhibit. I don't know what number we are at or how you would prefer to mark those.
Yeah, I have it. If you all want to deal with it, just more because you have yours identified in a particular way.
We do. It's, I believe, page 31 or 32 of Exhibit E. Yes, sir. So, I mean, it's in our Exhibit E.
Okay, well, what I was asking is, I want to identify a separate exhibit for opposition and application.
And then we're using letters, sir.
Okay, you're using letters.
And I'm using numbers of. We'll have independent designations related to my client's exhibits as well.
Could you just do H1?
So let me be clear, we are going to take it as an exhibit, whether or not it's valid or not is a question we can vet at some point.
It's just been identified as an exhibit.
H1.
H1. I think that was all the questions that Mr. Whitlock had. Mr. Adams.
Okay. Any more questions from the board for Mr. Adams?
Yes, I just have a few, and I will be brief.
Okay.
Mr. Adams, I had just one question. I will use the microphone. I apologize to members in the community. Mr. Adams, this is from your staff report, and I've just blown out a portion of it here that and highlighted the current land use you have listed as institutional. And I want to be clear about this. Is there any definition of institutional use in Montreat zoning code?
I could consult that shortly, but
would it sound right that that's not a defined use in the code?
This listing right here was for a generalized purpose. It's not any specific definition.
Gotcha. So that's more about ownership than it is a particular use. It's owned by the MRA as an institutional.
It's not intended for ownership. It's a descriptor of the general character of the land, the land as it's being used.
But to your knowledge, there's no definition of that in the land use code as of today, without having to review the code.
In the zoning ordinance.
Correct.
Yes.
Okay. Okay. I've thrown up, I'll just represent to you that this is the zoning map for the town of Montreat. And I know in your report, you had talked about town center. I want to be clear here. The commissioners here in Montreat have designated a town center overlay, correct?
That's correct.
Okay, and that's represented by the cross-hatched area on this map, correct?
That's correct.
Okay. This proposed use is not within the town center, correct?
It is not within town center zoning.
Okay.
It is within, the IR zone.
Yes, that is correct. That's the other color. shown
Within the IR, but not within the town center overlay district. Correct?
Correct.
Okay. My last question is one that I think Member James raised about commercial parking. You had indicated that the parking requirements were minimums, minimum requirements. But I want to be clear for the board through a conditional or special use process could impose additional parking requirements related to commercial use if it sought to as part of its approval of this project, could it not?
Yes, that's correct.
Okay, so the minimum is minimum of the ordinance, but in no way does that limit this board from adding additional requirements if it felt that those were necessary.
That's correct.
That's correct.
Okay. And those would be my questions for this witness. Thank you.
And if I may just briefly follow up on your institutional question, there is no definition of institutional or institutional in the zoning ordinance section of definitions.
Thank you.
Okay.
I do have questions. Looks like my mic is on. Very good. All right, so Mr. Adams, let's start with what I think has created some confusion. The special use permit that MRA is seeking tonight is part of the zoning ordinance, correct?
That's correct.
It's part of the town zoning authority.
That's correct.
Is the stormwater ordinance a separate ordinance from the zoning ordinance?
It is. It's in the general code of ordinances.
Okay, and Mr. Chair, may I approach Mr. Adams? I'd like to show him a copy of the town's stormwater ordinance.
If you could explain what you're showing. it would
All
be
right.
helpful.
So what I have here, sir, and this is in our exhibit. Exhibit I. We will be introducing this to our witnesses. I have a copy of the town's stormwater ordinance, and we'll be handing out a copy to all of you as well. And I simply want to flip the appropriate page here. Just if you all bear with me. I will certainly do that. I apologize. All right, so I'm going to stand on my tippy toes because Mr. Adams is a tall man. Oh, sorry. So could you read the title here, just so they know that you're reading from the stormwater ordinance, sir?
Certainly. Reads Montreat General Ordinances, Chapter K hyphen Environment, Article 3, Stormwater Management.
Okay. And if you would, could you read this this sentence for me, sir?
A building permit shall not be, a little closer, sorry. A building permit shall not be issued but for any development project until the required stormwater control permit has been issued.
So the applicant will have to get stormwater approval at some point, correct?
Yes, that is correct.
But this is a zoning proceeding and not a stormwater proceeding. Is that correct?
Yes, that is correct.
Thank you. All right, I will try and move through my questions quickly, Mr. Adams. So I want to direct you, if you have it in front of you, and if not, I can give you my copy, back to your staff report. Do
Yes,
you
I have
that,
a
Mr.
copy here in
Adams?
front of
Okay.
me.
If you would go to page 3, please.
Okay.
And under the staff report summary, am I reading this correctly, that we are proposing to demolish 3 existing lodges and construct a new lodge?
Yes,
Okay. That term lodge, is that the same thing as a hotel?
yes, the definition in the current zoning ordinance is hotel.
Let me see if I can put a finer point on this. And we will have our own witnesses that will confirm this. So I don't need a hearsay objection. We'll be corroborating it later in the presentation. Has MRA represented to you that it is not building a hotel?
No. Yeah, I'm sorry. Can you repeat
All
the
right,
question?
fair enough. So we are going to contend that we are building a lodge and not a hotel. Yet it is curious that we are seeking a special use permit for a hotel. And I'm wondering if you can provide some clarity as to why MRA would seek a special use permit for a hotel when what we are building is a lodge.
So the application for the special use permit has come in under the, what I'll call the existing or the new zoning ordinance, which was adopted June 10th of this year, and it went into effect June 18th. There is no definition of a lodge in the current zoning ordinance, so the language of hotel a hotel is a defined use in the current zoning ordinance, so that may be some of the confusion of nomenclature or what have you, but the term that's defined and the use that's defined is hotel.
Is it fair to say that the term hotel in the current ordinance is the closest thing to a lodge?
Yes, previously, this use had, lodge was a defined use in the previous zoning ordinance.
Thank you. Let's see here. I do also want to go to your page 12 of your staff report. And this is really just a matter of clarification. There is a recommendation from staff that Collegiate Circle be turned into a one-way street. Is that correct?
To clarify, it already is a one-way street. The staff recommendation is to reverse the direction of the one-way street.
Okay, thank you. I apologize for any confusion.
That's okay.
I would take the position that while that may be advisable for the town to undertake, that is not a condition that could be imposed on a special use permit. Do you agree?
No, I do not agree.
So you're taking the position that they could, as a condition of the special use permit, require the rerouting of a one-way street that is a public street controlled by the town of Montreat.
Yes.
Now, isn't it also true that the town of Montreat, the governing board, is the only body that can change the direction of a one-way street?
Yes, that is correct.
So you're proposing a condition that is contingent on further approval by the governing board.
Yes.
And what would happen if the governing board said, we're not going to change the one-way street? Would then MRA be denied their ability to build their project, even if they are granted a permit?
I don't know.
Okay, well, thank you, sir. Let's see, if you could go to page 16 of your staff report. And again, this is just a very quick clarification. Mr. Whitlock spent a lot of time talking about setbacks and things like that. The lodge, if it's built, will be further back from the setback than the current structure. Is that correct?
I'm sorry, which structure are you asking
The
about?
lodge, it'll be further back than the Galax house. My apologies.
I'm sorry, which house? The Galax house?
Yes, sir.
I would have to have the footprint of the existing buildings and that of the proposed building in front of me to answer that.
That's fair enough. We'll move on. So it's also correct, MRA is proposing to put in an evergreen buffer along the property line. Is that correct?
That's what's shown on the application. That's
Okay.
correct.
Thank you. Let's see, if you would, please go to page 20 of your staff report. And there was, again, some confusion. I think Mr. Noor has accurately stated that
You said page 20, correct?
I'm sorry, yes, sir, page 20 of the staff report.
Okay, just give us a second.
Oh, please,
Follow.
yes.
Okay.
Mr. Adams, are you ready? Please?
Yes.
Okay. So Mr. Noor has stated that the zoning designation for the property is not Town Center 1, and you testified that that's correct.
I would object. I
I'm
don't, that slight mischaracterization. I said
Okay.
town center, not town center 1.
Thank you, sir. I appreciate that. The point I'm getting to is that there is some slippage of language between the zoning ordinance and the comprehensive plan. Because as I understand it, in the comprehensive plan, the area is listed in what is known as Town Center 1 or Town Center. Is that correct?
That is correct. The the land use policy intent of the comprehensive plan listed as Town Center 1.
So, so in the comp plan, it's Town Center 1. The zoning, however, is IR.
That's correct.
Okay. And could you read from,
If we could just take a 5-minute break with Mr. Chairman.
I don't even need 5, just give me.
my apologies, Mr. Chair.
Mr. Morphy, we are struggling to find the page you're referring to up here. Can you
I'm
show
sorry,
it to us?
may I approach, sir?
Sure.
And
Got it.
So his staff.
It is. That's okay. I'll read off Eleanor's, we'll be fine.
Yeah, it's part of your agenda. You should have had this. Mr. Morphy, thank you.
absolutely. Okay.
I apologize. I've been triple vaccinated, so
So, Mr. Adams, I'm going to show you a passage from the comp plan that's in your staff report. I'd like you to read it to the Board of Adjustment, please.
It's the, excuse me, it's the first set of language under Town Center 1. Town Center 1, TC1 in parentheses, is planned mostly for institutional uses and activities centered around the MRA. In addition to institutional uses, this area could include office, civic, residential, and service uses. In TC1, Town Center 1, the possibility exists for collaboration between the MRA and the college to address housing needs, especially the lodging needs the MRA experiences during the peak summer visitor season. The joint use of facilities could be encouraged here.
Thank you, Mr. Adams. So the comp plan for the town center area specifically calls out lodging needs for the MRA. Is that correct?
That is the language that appears there.
No further questions.
Mr. Chair, I just have one quick follow-up based on a question Mr. Morphus asked. Josh, if you could share my screen, please, sir. Mr. Adams, Mr. Morphus asked you some questions about the distinction or lack thereof between a hotel and a lodge. This is the definition of a hotel in the zoning ordinance. Would you just read that into the record, please?
A building or a building in which sleeping accommodations are provided and offered in the to the public for compensation, in which the rooms are usually occupied singularly. Sorry, I'm having trouble reading that.
I apologize.
For rent. And in which there's usually a kitchen and public dining room for the preparation and service of meals. Sorry, I don't have my glasses with me.
No, that's okay. And then the last sentence does say the term hotel includes lodges, inns, and motels, correct?
Yes, that is correct.
Okay. But that definition does expressly contemplate the provision of rooms to the public for compensation, correct?
Yes, that is the definition shown there.
Thank you, Mr. Adams.
No further questions.
I've got just two follow-ups, I think. Mr. Adams, you were asked about the Town Center 1 versus IR designations. I think you read what you were just reading was from the comp plan and the TC1 that talks about the institutional uses. And I want to be clear, that's from the comp plan, correct? That is not the zoning ordinance, correct? Okay. And in the zoning ordinance, in the IR institutional district, do you mind? I think the board can see it. I don't want to waste time by reading it in there, but in there it says, and I'll read, and just correct me if I read it wrong, but it's to provide a zone of transition between purely residential and purely institutional districts to serve as a residential district to accommodate institutional district, correct?
Yes.
Okay.
Well, I'm gonna clarify my answer in saying it is literally called institutional residential.
Understood. Fair enough. I want to ask about one other distinction. You were asked about the stormwater, and I'd like to throw up here. This is section 310.622. These are the conditions this board has to affirmatively find in order to approve a proposed use. And as we're looking at this, and I'll just read, and correct me if I read it wrong, it says the use meets or will meet all the required and applicable development standards and conditions of the town of Montreat. Did I read that correctly?
Yes.
And then it says, including without limitation, all development standards, conditions, and requirements related to utilities, parking, access, and stormwater drainage, and the applicable regulations of the zoning district. Did I read that correctly?
Yes.
And then at the end there, it says, except as such regulations may for each case be modified by the Board of Adjustment, correct?
Correct.
So the ordinance empowers this board to apply conditions related to those as part of its review in this process, correct?
That's my understanding of the reading, yes.
So it's not just, we'll do this in the future. This board actually has an affirmative role to play in what might be required of this if it were approved. So showing compliance and how that would occur is important for them to be able to do their job of applying conditions if they so choose. Is that fair?
Yes.
Okay. Those are my questions.
I have no further questions, Mr. Chairman.
You can keep our lights down if you want to.
Thanks,
It's
Scott.
hard to see everybody. That's why we keep asking questions, so we can't see what you're
I
saying.
thought I was getting a nasty stare from one of the board members, and I'm just glad to know it's the lights.
Yeah, we can't see what you're saying. It's hard. Yeah, that's why we're asking questions.
Mr. Chairman, I just have a few, I have to, for the record, I just have a few questions for Adam. Was the property properly posted in anticipation of this hearing?
Yes.
My question was the property properly posted in anticipation of this hearing?
Yes.
Was notice adequately sent pursuant to state law and Montreat's ordinance?
Yes.
And was the special use permit application, was it properly advertised?
Yes.
And you created a staff report that everyone's been testifying to? we're just gonna ask that that be admitted into evidence.
Yes, I created the staff report that everyone has been collectively referring to.
Any more questions from anybody? I guess the next one up. Thank you, Scott. Thank you, Shane. Council.
Yes, sir. Again, we kind of jumped right in with standing. So the board will indulge me. I'm going to just very briefly give you a little bit of an introduction. Again, my name is TC Morphus. I'm an attorney with the Bro Law Firm. We're out of Chapel Hill, but we do land use work all over the state. My co-counsel, Mr. Bob Ost, is an attorney with McGuire Wood Bissett at Chapel Hill. He unfortunately could not be here tonight, but he has been texting me regularly. So if you see me looking at my phone, I'm not watching TikTok videos. I am communicating with Mr. Ost. We have a number of witnesses tonight that are going to present information to you. We believe will show we comply with all standards, both of the zoning ordinance generally and also with the special use permit requirements specifically. Also, as opposing counsels rightly pointed out, there are other applicable ordinances, and we'll be discussing those as well. I had in my notes to make sure the board knows they can ask questions, but you all seem very comfortable with that. So please continue that. What I don't want is to get to the end of this process and you feel like there's anything that you need information on that you do not have that information. We'll do our very best to answer any question that you present. So unless you have anything of me now, I'd like to go ahead and present our first witness, Mr. Richard DeBose. My apologies. We will not do that again.
Again, if you could turn on the lights, we'll be able to see the front row and the speaker.
And before Mr. DeBose gets started, we have an exhibit notebook that we prepared. I'd like to hand them out now to everyone. We also have them for opposing counsel. What we're going to do is go through them and we will ask that each exhibit be admitted into the record as we proceed. So don't feel like we're trying to slide anything in on you.
Mr. DeBose, you have been sworn in?
I have not.
Okay.
I don't think so.
I guess if we have a Bible there.
Got one right here.
Raise your right hand. Do you solemnly swear or affirm that the evidence you're about to give the board in this session shall be the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
Thank you, sir.
Just a few more, Mr. Miller.
I'd like to give this to the tree board if I could.
Okay, I'll take this.
Yeah, take that one, and then maybe share.
Oh, you want us to share? That's fine.
No, we have a copy.
But the tables are small, so.
But our mind is big.
Like the book of life.
So they said.
Also as a preliminary matter, these are our exhibits. A, B and B are the charter of Mountain Retreat Association. Mr. DeBose will be talking about that in a moment. We also have the charter of the town of Montreat. We also have certified copies of the town code of ordinances, the town zoning ordinance, and the town comprehensive plan. And we would ask that they be admitted into the record. Are there any objections to that?
No objections on my part.
Okay, and
No objection.
thank you, sir. And if I could, I'd like to just hold on to these in case we need to refer to them. But at the conclusion of the public hearing, we will make sure that this is given to the clerk for the record.
I'd like to apologize if we could. We need to take a quick break, if you don't mind. So we're going to take a break and we'll go ahead. We've been going about an hour, so let's go ahead and take the 15.
Okay.
And then we'll come back.
It's in the town.
I've never.
So what we're gonna do.
We're gonna have to close the store.
Okay, guys. We don't need any of these lights.
Fan or light?
The light, it's very, very,
Do whatever makes you comfortable.
he can get it up there. He can do it up there.
No, we're listening.
I mean, it's shining.
And that's big LEDs.
Yeah, it is. It's a big. I mean, they tried to help us out.
Probably on this one too.
That's not to get over there, just wait for you.
Okay, if we would, come to order.
I believe, okay, we're on. So before Mr. DuBose proceeds, I've been informed that I misspoke earlier and I said Bob Ost is an attorney from Chapel Hill. He is certainly not. He is an attorney from Asheville, North Carolina. He has been in Asheville since the dawn of time. So I apologize to Mr. Ost. All right, so.
And the board has one request, if the speakers are comfortable taking off their mask, it helps facilitate.
Okay.
Yeah, you can
Very
take it
good.
off and you don't need to get right up on the mic. I think it's gonna be good.
Okay.
Thank you.
Does that make him more credible if he's from Asheville? Or as a
Well,
witness?
I hope it doesn't make him less credible that I confused him with being from Chapel Hill.
He's Moses around here.
So if I may, I'm going to hand Mr. DuBose, our witness, or our exhibit, hand a notebook.
I have been sworn in.
All right. All right. Mr. DuBose, I have opened the notebook to Exhibit D. Could you tell us what that is, sir?
It appears to be an application for a permit for approval for a lodge at 309 Collegiate Circle submitted by the Mountain Retreat Association.
Okay, and are you familiar with this application, Mr. DuBose?
I am familiar with it. I was the principal actor in our organization who worked on it and submitted it. It is my signature on it.
And to that question, could you please give us your name for the record and also your position with the Mountain Retreat Association?
Sure. I am Richard DuBose, and I'm president of the Mountain Retreat Association, which does business as the Montreat Conference Center. And my responsibilities in that organization include managing and directing a staff of 75 staffers year-round and some 200 in the summertime to help the conference center pursue its mission and ministry.
Okay, thank you. You prepared, you're familiar with the exhibit or with the application, you're familiar with the application. Can you tell us who prepared the application, Mr. DuBose?
Sure. Several members of our staff participated. In addition to staff, primarily senior staff. Samsel Architects in Asheville, North Carolina, is the architect principally responsible for the design that is in the proposal. They worked very hard on the proposal. People in Montreat will know Samsel because they have designed several homes here in Montreat. Frank L. Bloom Construction Company is the construction manager on the project. And so you all will know them as folks who have well, right now they're developing and have been the developers of a lot of the work over at Highland Farms in Black Mountain. They are the construction managers on the project and also participated in the preparation of the application.
Okay, and if you would, tell us a little bit about the function of the Montreat Conference Center.
So Montreat Conference Center is a affiliated conference center and convening ground of the Presbyterian Church USA. As such, we are responsible for the pursuit of Christian ministry here in the Valley. As a conference center, we convene people in Montreat year-round, predominantly in the summertime, but we are a 12-season conference center. We are known for all kinds of programming, probably in the denomination, principally for youth conferences. We gather in Montreat every year, in a typical year, a non-COVID year, some 5,000 young people in one of 6 youth conferences that take place in the summer months. It's probably definitely the largest annual gathering of Presbyterian youth in the Presbyterian Church USA. We also host conferences that are put on by other organizations. Another example of that would be the annual conference in the summertime of the Worship and Music Conference of the Presbyterian Association of Musicians that takes up a couple of weeks of our summer schedule. We host church retreats, not just Presbyterian Church USA church retreats, though I would say that is certainly the majority of the churches who come and retreat in Montreat. But we also host churches from other Presbyterian denominations, from other denominations, from non-denominational Christian faiths, and even some non-Christian faiths occasionally. Though again, most of that is Presbyterian related. All of this sums up under the heading, and all of the work that we do is to help people grow in their relationship with God and in their commitment to Jesus Christ. We provide recreation programming all under this heading. And of course, we provide a good bit of the amenities that exist here in the middle of Montreat for residents, for part-time residents, for guests, conferees, and others who travel to Montreat.
Okay, thank you, Mr. DeBose. Now, before we go any further, I don't want to get ahead of myself. Exhibit D has already been admitted into the record, but if there is any question about that, we ask that it be admitted. It's simply the application for this special use permit. All right, hearing no objections, we will move on. Mr. DeBose, could you open that exhibit notebook I gave you to exhibits A and exhibit B and tell me what those are, sir?
Exhibit A is the charter of the Mountain Retreat Association.
Okay, and what is exhibit B, sir?
Exhibit B is the charter of the town of Montreat.
Okay, and I have already asked that a certified copy of the charter of the town of Montreat be entered into the record. But could you take a quick look at exhibit A, and is that a true and accurate copy of the Mountain Retreat Association charter?
It appears to be a true and accurate copy of the town of Montreat charter, though you will note at the bottom of the first page, there are several dates, some of which defy my contact lenses. It's important to note that the charter has been amended several times through the years, but I believe this is, if not the original charter, certainly a very early version of it.
Okay, thank you, sir. We'd ask that exhibit A be admitted into the record.
So moved.
No objection. Thank you, gentlemen. So if you would, Mr. DeBose, briefly describe the history of the Mountain Retreat Association and its relationship to the town of Montreat.
Oh, well, the Mountain Retreat Association, in some sense, was the original town of Montreat. The Mountain Retreat Association was formed in 1897 as a nonprofit stock corporation, unusual organization. And under the charter, its purpose was to act as a convening ground and assembly ground for Christian work, Christian ministry, Christian mission here in the town of Montreat, principally at that time for the Presbyterian Church. Well, later, a decade or so later, that became for the Presbyterian Church of the United States. Interestingly, in that document, as I said, the MRA was also granted municipal powers and responsibilities. So in effect, was the town before the town. Under those municipal powers, the MRA had the responsibility to provide water, sewer, roads, typical municipal duties. It also had the authority to do things like start schools. So for example, we're on the campus tonight of Montreat College. What is today Montreat College was founded by the MRA in 1916 as a function that was granted to the MRA by this original charter. And there are other municipal responsibilities that original charter provided. And until 1967, that's essentially how Montreat operated, with the MRA being the principal authority. And this property in the valley was all private property, in essence, that was governed by the Mountain Retreat Association. In 1967, of course, this I guess gets to your second question about its relationship to the current town of Montreat. And to Exhibit B in your packet, in 1967, the MRA created the town of Montreat, and in so doing, transferred most of those municipal powers, I guess all of the municipal powers, to the town of Montreat. And since 1967, the town of Montreat, as we know it today, has been the municipal authority here in the valley. Interestingly, to your question, the MRA did not transfer a missional provision of many amenities that people typically associate with municipalities. And so to this day, the MRA continues to provide municipal goods and services, programs, activities, and facilities to the community, to full-time residents, to part-time residents, in addition to guests, conferees, and others who come to Montreat. So, for example, Robert Lake Park, the wilderness area that we've placed into conservation easement, that we co-manage with the Appalachian Highlands Conservancy. All of these municipal responsibilities continue to be missionally carried out by the conference center, and you can trace the missional importance of that all the way back to the original charter. We have not relinquished those responsibilities missionally.
Okay, thank you for that, Mr. DeBose. If you would, open the exhibit notebook to Exhibit C. And if you would, please tell me what that is a copy of.
It's a copy of a web page on the Town of Montreat website.
Okay. Does it appear to be a true and accurate copy of the website as you are familiar with it?
It is and does.
Okay, we'd ask that it be admitted into the record. Okay.
No objection.
Thank you. If you would, I would like you to start at the bottom of the first page where it says, "What is Montreat?" And then if you would read through that paragraph 1 on the next page, sir.
Okay, so the question at the bottom of the first page is, what is Montreat? And this is a reading of the next page. Sometimes it looks like a conference center, other times it looks like a college, and it always seems like a small town. In fact, it's all three. Montreat Conference Center, is it, you want me to read this number 1?
Yes, sir. You don't need to read the website.
Okay. Since 1905, the Montreat Conference Center has been serving the spiritual, renewal, and recreational and rest needs of guests, also known as the Mountain Retreat Association, from which Montreat is derived. It is a church-related institute affiliated with the Presbyterian Church USA. The Conference Center offers conferences throughout the year. Facilities are available for church and group retreats. Recreational opportunities abound in the natural beauty of the cove and the surrounding mountains, including a playground with 2 streams running through it. Montreat is a very special place because of the conferences.
Okay. So is that an accurate summation of the relationship between the Mountain Retreat Association the town and the college and the history of the area. And of course, I didn't ask you to read the entire page, but
I am familiar with it, and it is a brief but accurate description of the relationship between the three institutions, yes.
okay, thank you. Well, let's move on from background information and talk about the project that we're specifically here for tonight. Now, this is much, of course, for your benefit as for the board's benefit. We're going to be providing detailed testimony from qualified experts about architecture and other technical aspects. But in general terms, Mr. DuBose, could you tell us what the MRA is seeking to do?
Yes, we are seeking a permit for the construction of a new lodge to replace 3 existing lodges on the property that we've already reviewed this evening. We're doing this for the following reason, well, several reasons, but reasons that began years ago when our board began studying how to improve and update the existing lodging that we offer. We own 13 lodging facilities in Montreat. And we found increasingly as we were, offering these lodges to our constituencies, that increasingly people, particularly adults, were interested in a particular kind of lodging, lodging that we were increasingly having a hard time providing. They want rooms that are in good condition. They want rooms that are conveniently located to other facilities on our campus. They want rooms, particularly the older they get, they want rooms that are easily accessed, ideally by an elevator, from parking and or from to where they eat, where they meet, and so forth. And then they want basic, and I mean not luxurious by any means, but they want basic amenities. In particular, they mentioned to us several times they would like to have their own private bath en suite connected to their rooms. This became a refrain. We did an analysis of our lodges. We have, depending on how you count them, some 235 to 240 rooms on our campus among those 13 lodges, and only about a third of them met these conditions and met that description. So we clearly had an identifiable need if we wanted to encourage and increase and enhance our ministry and to offer opportunities for more people to come to Montreat. Increasingly, that study focused in on new construction. We certainly looked, and I could take you through an examination of each one of the 13 lodges and the different options that we considered. And many of them resulted in really wonderful new uses for those lodges. But ultimately, we decided that a new lodge was the appropriate avenue for us to enhance our ministry, both through the provision of hospitality and improved hospitality, in improved programming, and the facilities that are associated in the lodge that will offer us to do that. And also that will increase the financial stability of the conference center, which is very, very important, obviously, not only for the provision and continuation of our ministry and mission, but we think to the whole town of Montreat and everyone who loves Montreat.
Well, and you got into my next question a little bit, Mr. DuBose. How does the lodge fit in with the MRA's mission?
Well, I mean, again, from exhibits A and B and C, I think everybody would agree that it is Montreat's mission, that is a through line from 1897 all the way through the present day, to invite people to come to Montreat to experience what we have here. Some people describe it as a thin place. Some people describe it colloquially as a place close to heaven, but in effect, a place where God's voice seems to be particularly evident. I believe God's voice can be heard everywhere, even in the darkest place. But I think many people, perhaps even most people who've come to love Montreat through the years, really prize it, particularly because of this unique characteristic, maybe not unique, but particular characteristic that Montreat has, that being here helps encourage people toward an attitude of contemplation, ideally toward an attitude of deepening and spiritual commitment in some cases, And so obviously a lodge that would invite more people here and would make it more conducive for people to come to Montreat fits very comfortably within our missional purpose. There is a second missional component to it, though, as it relates again to that third element that I mentioned a minute ago, and that is as it would, we are confident, further strengthen the financial foundation of the conference center. We would offer and do devoutly believe that everyone who has an interest in Montreat, who participates in the community life here in Montreat, should have an interest in this permit being approved. If you are one of the financial pillars of the conference center is the revenue that our lodging provides for people who come to Montreat and stay, who don't own homes here, who come and stay in our lodging. That revenue that we accrue from our lodging is applied to virtually everything else that we do. So for example, if you enjoy Robert Lake Park, if you enjoy a walk around the lake, if you enjoy our conferences and programs, all of those things are subsidized, and the provision of those of amenities, those facilities, they're all subsidized by revenue that we gain from lodging. So just beyond the fact that it has a missional purpose in inviting people to Montreat, anyone who participates, even if they never spend a night in this lodge, we believe will benefit from the lodge because of the way it will further subsidize and sustain the various ways that we participate in and contribute to life here in the Valley.
Okay, let's dig in a little bit more to some of the specifics of the project. I asked this to Mr. Adams. This may be a bit of a theme, but very briefly, can you tell us why you're applying to build a hotel, even though it's a lodge that you're seeking permit for?
Well, the code, we're applying for a permit to build a hotel because that is what the code requires, as I think was stipulated earlier in the conversation. We are calling it a lodge in our testimony tonight because that is the intended use of the facility. As I said earlier, we operate a number of lodging facilities here in Montreat. Many of you, perhaps all of you, are familiar with Assembly Inn. You may be less familiar with some of the other facilities that we have around campus, but virtually all of the others are a lodge in one form or another. And by that, what we mean is we typically rent lodges to groups. We rent lodges to church groups, whether they are here to attend conferences or whether they're here on their own church retreats and so on and so forth. So lodges have certain characteristics. They have design characteristics, which our testimony will present to you all this evening. And of course, they have operational characteristics, which I can testify to in terms of how we use a lodge that differs it from how we use Assembly Inn, the kinds of people who come here who prefer one versus the other. We don't have in our inventory of 13 lodges currently, 13 facilities currently, we don't have a facility like the one right now that we are proposing to build in terms of its some of the characteristics that I outlined earlier, in terms of the condition that this would provide our guests, in terms of the other features that the new lodge would provide. And so, and yet, in terms of how we plan to use it for group rental and group use, it's more like a lodge and less like Assembly Inn.
Okay, thank you. Can you briefly describe the property and immediately surrounding structures, and how long has MRA operated a conference center at this location?
Well, that's a good question. So there are, as we've seen on the slides earlier, there are 6 different structures on the property. The 3 to the west, Reynolds Lodge, Hickory Lodge, and Walnut Lodge, are all in good condition, and our intention is to continue using those as they are currently being used as lodges. We have owned, well, Reynolds Lodge was built in 1992, I think, 92, 93, by the MRA. Hickory Lodge, which was once called Collegiate Home back in the day when I was a kid, that's probably where Collegiate Circle gets its name from, Collegiate Lodge was formerly owned by other institutions and used as a lodge. I think ownership was transferred to the MRA in 1970. I'm up here without notes, but I'm not precisely sure of that date, but it was around that time. And then Walnut Lodge we acquired in the recent past, 2016, 17, something like that. It was a private residence, was acquired by us and renovated and has been used as a small lodge for members of staff, visiting guests. It's a very small structure, so it only houses a few people. The other three lodges on the property, Galax Lodge, Lord Apartments, and Chestnut Lodge, are the lodges that would be removed so that we could build the new proposed lodge. The Galax Lodge, I think, has been owned by the Conference Center since the early 2000s. It was when we acquired, just like with Hickory Lodge, and just like Hickory Lodge, when we acquired Galax Lodge, it was in use essentially as a lodge. It had been furnished with multiple bunk beds and so forth throughout the facility by the previous owner. So I don't think it was an institutional use. The two other facilities, which are face Georgia Terrace at the top of the property, Lord Apartments and Chestnut, were both acquired, I think, by the Conference Center sometime around the early 1980s. Before Montreat acquired Chestnut, before the MRA acquired Chestnut, I believe it was called the Truva Apartments. And again, both of these facilities were lodges before the MRA owned them, and they've been operated as lodges since that time.
Okay, thank you. What's the busy season for the Conference Center?
The busy season is about depending on how you calculate it in any given year, a 9 to 11 week stretch that starts in late May, early June, and goes through mid-August, during which we have our summer conference season. I would say somewhere in the neighborhood of 55 to 60% of our revenue, for example, is received in the first 4 months of the fiscal year, which begins May 1st. And so it really does represent a pretty substantial percentage of our year-round business. And that's a good question, because the lodge's purpose, because of the way we currently do our ministry, will change a little bit from the intended purpose anyway, or the reason for the use, I should say, will change a bit from the summer season to the fall, winter, and spring. We certainly do retreats, most of our retreat business in the fall, winter, and spring. We continue to do conferences during that time. But as I said earlier, in the fall, winter, and spring, as opposed to the conference in the summer season, you have more adults as a percentage of people who are here, and families as opposed to a predominant youth population in the summer. So in the summertime, we have, in a given summer, somewhere in the neighborhood of 30% to a third of the people who attend conferences here in Montreat will stay in our lodging, and the remainder will stay in lodging elsewhere in Montreat or sometimes in Black Mountain. The advantage of the lodge that we see, and the 20 additional rooms and in the improved condition of those rooms, will give us enormous flexibility and the ability to help house many of those people who come to Montreat already in the summertime, and to accommodate folks already coming who are finding it increasingly difficult to find lodging in Montreat. Our experience is that the housing market may be changing a little bit, or I should say the rental market may be changing a little bit in Montreat, as our staff, our program staff, repeatedly works very, very hard and struggles in some cases to find suitable lodging for the groups that want to be here. So in the summertime, the lodging is really going to serve folks who are already coming to Montreat but are struggling to find suitable accommodations. In the fall, winter, and spring, again, this is where we hope to expand people's interest in coming to Montreat and to grow our ministry in those seasons by providing a more attractive, a more accommodating, a greater hospitality experience and program experience that we believe the lodge will offer.
And I believe you said this, but I want to make sure. You said that 20 years ago, Montreat accommodated about 2,000 more conferees in the summer than you do today.
Well, I don't know that I said it, but
okay,
it's true.
Thank you.
So I think what you're referring to is that our conference attendance year round has basically remained stable one year to the next over the last 20 years, but it has redistributed itself. So you're right, about 20 years ago, you would have found about 2,000 more conferees, give or take, in the summer here in Montreat than you do today. And those 2,000 that might not no longer come in the summer have been replaced by a little bit higher activity in the fall, winter, and spring. And that's just because of the evolution, as I said earlier, of the conference center from being predominantly a seasonal conference center, seasonal ministry that predominantly relied on summer activity, to being more of a 12-season conference center.
Okay.
I'd like to ask a
Oh,
question.
yes, sir.
What is the current Assembly Inn considered? A lodge, a hotel? What is it considered?
Well, that's a good question. If you're asking a question as it relates to zoning, I'm not a zoning expert. I can tell you how, from an operational perspective, Assembly Inn differs from the proposed lodge. Is that the?
No, I was more going, we're kind of having this is a lodge versus a hotel. I'm trying to understand the significance of that as it relates to the zoning in this request. A lot of talk about it.
Right.
I'd like to know what the difference is. What, other than it's an internal thing, other than there is a reference to it, a hotel can be called a lodge or a this and that.
And-
Yes.
And Mr. Chairman, if I may, our testimony, we believe, will demonstrate that a lodge use has a different and less impactful or less impact than a hotel use. That's one of the reasons we're making this distinction. But I'll let Mr. DeBose answer your question.
I will just answer from an operational perspective and how Assembly Inn operates and how we envision this new lodge operate. So Assembly Inn has a commercial kitchen. When you stay in Assembly Inn, typically, in addition to your room rates, you pay a meal plan. And so you eat in a communal kitchen, and you might have the entire inn to yourself, or it might be a number of groups, or there might be some individuals there even in some cases. And they come down and they share a lobby. They alternate the use of meeting space, and they tend to eat together at prescribed times throughout the day. And there are people here, when they come to Montreat, that's the experience they want. There's a definite interest, there's a thirst, there's a market for that kind of experience. Separately, or sometimes distinctly, there are groups who come to Montreat who want a very distinct, very discreet, very sequestered experience here in Montreat. They want their own space. They want to rent the whole space and have space that is dedicated for their use throughout their stay in Montreat, whether that be a Friday to a Sunday or a Sunday to a following Saturday in the summertime. And so lodges, as we describe them operationally, are set up to provide that experience for those guests. So as you will see in the design that we present when our architects get up and talk about this lodge has several design characteristics to promote and to respond to that desire, but to do so in a more modern, convenient, and accommodating way. That, by the way, it does share with Assembly Inn, which does have rooms with ensuite bathrooms, which does have elevators, which is easily accessed, which is central to our campus. So there is an overlap in terms of the things that they do, but there's a distinct characteristic to the differing experiences one has when, say, one stays in Assembly Inn and is usually a part of a larger group from people, and there's certainly many benefits to that. As it relates to that, or coming here, say, as the First Presbyterian Church of Charlotte, North Carolina, and having a distinct space with distinct meeting space, a kitchen where your cooks prepare your meals, and you're totally responsible for the programming and the hospitality experience that you all have while you're here. And in those cases, unlike at Assembly Inn, you wouldn't have daily maid service. You wouldn't have. You would be responsible for that portion of the lodge, whether it's Winnsboro, Glenrock, or in this case, the proposed new lodge, while you are renting the space.
So as our determination, we're referring to it as a lodge, but it's actually a DBA of a hotel from a law perspective.
I think it's fair to say that the zoning ordinance definition is hotel. And Mr. Whitlock accurately pointed out that the definition of hotel, and I'm paraphrasing, includes lodging and other similar uses.
Just follow-up question, Chairman. In your presentation, there's an implication that this is less transitory or longer stay and less vehicular traffic and all that. Are you going to address that with the transportation engineer at some point?
Thank you, sir. Yes, we will be presenting a transportation engineer. They'll be talking about the traffic impacts of the proposed use. Without asking Mr. DuBose to talk about things for which he's not qualified, I think he could talk about things like what does the stay typically look like?
Yeah, length of stay. I think.
Yeah.
I think
Would you like Mr. DuBose to answer that?
if he's comfortable?
Sure, I'm comfortable, though I think I'd like to take your question in a slightly different direction. The length of stay is not likely to be substantially different from the length of stay someone might enjoy at Assembly Inn. But there has been some question in the community and some question as we have planned this about things like delivery vehicles, staff coming and going, delivery trucks bringing, commercially prepared foods for a commercial kitchen and so forth, like you would find at Assembly Inn. That kind of activity taking place, going to and from this facility as a lodge would not be present. We would be operating and effectively cleaning and maintaining the lodge between occupancy, as opposed to during occupancy, the way it typically operates at Assembly Inn. So you're going to have less activity on the site. If you are familiar with Glen Rock on Kentucky Road, if you're familiar with Windspur Lodge right over here, down from this facility, if you're familiar with Reynolds Lodge, Balsam, Sylvan Lookout, these are lodges. And so you don't tend to have that kind of vehicular activity and human activity going to and from the property during our guest stays. They have it while they're there.
Okay.
I have one question also, again, kind of towards this. Is this going to be a facility that could accommodate, let's say, a large wedding?
A large wedding?
Yeah, someone wants 40 rooms, they want to have a wedding there. I mean, is that a possibility?
I suppose it's a possibility, sure. I mean, a wedding is a worship service, so it is certainly a possibility. We don't very often do weddings. We're not
a new facility with conference rooms,
well,
hotels.
many people would tell you Assembly Inn as a facility is well set up to accommodate weddings. Our staff doesn't have a great deal of expertise in executing weddings, so we do them occasionally. They don't tend to be the large kind like you would find in a large facility. But sure, people get married in Montreat all the time. And so it's certainly possible that people staying at this lodge could be the guests of a wedding party that took place either on that site or around Lake Susan or one of the many places where people get married here in Montreat.
Okay. If you would, Mr. DuBose, tell us a little bit about how your rentals go. What typically fills up first? What are you, and then are there any facilities that are harder to rent or that you don't currently rent to the public?
Sure. Well, again, depending upon what the experience is that people want, the lodges that are in better condition in our larger conferences, the lodges that are in better condition like Reynolds and Winnsboro and Glen Rock, and for those in the Assembly Inn in particular, fill up first, in some cases almost immediately in a typical season. And then the lodges that are, shall we say, in less good condition than those sort of frontline lodges fill up later, or in some cases don't fill up at all. And of course, in the case of the lodges that we're proposing to replace, a Galax Lodge, which is in very fine condition, only accommodates a few people. So it really is a very small lodge, and for the size of the property that it's on, we don't find that that is an efficient use of that property. The other two lodges, Chestnut Lodge and Lord Apartments, are in significantly worse condition. Chestnut Lodge is not winterized and so is not rented in the fall, winter, and spring. I will let our architects speak to the design limitations as it relates to both Chestnut and Lord. But it's clear that from an operational perspective, neither lodge really will help us accommodate the goals that we've set out for this project for a variety of reasons. Lord Apartments, well, it's the lowest ornament on the tree. We have not rented Lord Apartments to anyone's memory for any reason other than to cover the cost of utilities in the last 15 to 20 years. It is in a condition such that we use it for the housing of mission volunteers. We will occasionally let staff stay there who are coming for the summer and are going to be here for brief periods of time. But for many reasons, it is not really a marketable lodge. So we've of course looked at Lord 9 different ways to figure out how to solve for that problem, and have concluded that replacement is by far the best answer from a stewardship perspective.
Does Assembly Inn fill up quickly?
Very quickly when we have a large group coming, yes. Assembly Inn is generally the preferred property because, as I said earlier, Assembly Inn provides the kind of lodging, particularly in the fall, winter, and spring, that adults particularly want these days when they travel. Assembly Inn, for lack of a better phrase, contains virtually all of what you might call grade A lodging in our system. So it does tend to fill up first.
Excuse me, I have one more question.
Sure.
The other 3 lodges that are on the campus that we're talking about, Walnut,
Reynolds and Hickory.
right?
Mm-hmm.
Not during the summer, but on the off season, about how many days in the off season are those rented?
So it's hard to tell you in terms of number of days. It's probably easier to do a comparative in terms of, say, occupancy rates, annual occupancy rates. In the summer, Reynolds, Hickory, and Walnut are pretty much occupied 6 nights a week, okay? In the fall, winter, and spring, substantially less, such that the overall occupancy rates for those lodges would fall somewhere in any given year, somewhere between in the high 20s to the low 30s in terms of occupancy rate, compared to Assembly Inn, which the occupancy rate in the last year pre-COVID approached 50% occupancy. So most of that gain that you're seeing in occupancy rate for Assembly Inn over those other 3 lodges occurs and is built up during the fall, winter, and the spring, since the occupancy rates in the summer are more or less equivalent. Does that help?
Yeah, so the whole campus as a whole, those 6 buildings, is it safe to say, once the summer is over with, they are not as rentable?
That's true. That's true by degree. So Reynolds rents more Reynolds and Hickory are both winterized. And so they do rent in the fall, winter, and spring, but not to the extent that Assembly Inn is occupied in the fall, winter, and spring. Walnut is sometimes occupied, but again, it has a sort of a special use, no pun intended. It's got, we put small leadership groups there. It's got 3 bedrooms. It's a small cottage. And so it's kind of on its own island in terms of how it is used. But yeah, that's generally the case. And then of course, Lord Apartments, as I said, is never rented for profit anyway, for gain. And then Chestnut, because it's not winterized, its occupancy rates are probably the lowest among all of the lodges that we have that we do rent.
Mr. Morphus, can I ask a question? If you may want to defer on this.
Okay.
When I was 16 years old, my sister had a date. My dad was not opposed to the date, but the cat showed up in a conversion van. My dad said, no way, because it wasn't the fact she was dating, it was the fact that the cat that showed up was different and odd and didn't fit in our group. In the profile of this guest, I don't get the sense that your guest to the lodge is going to be any different than what we see here today. You're targeting, it's basically, if you look around this room, it's going to look like us, or it's the same thing. We're not talking about targeting a completely different group than what's already here, are we?
That is correct. Very good point. The constituencies that we market to and that we look for the people that we seek to bring to Montreat are groups and individuals that are found within our traditional constituencies, and those aren't anticipated to change a great deal. They are people seeking in the main, some kind of spiritual experience, some kind of expense, and this can be from the most devout cradle to grave Presbyterian all the way down to the most skeptical agnostic, mind you, of course, but because we do accommodate all those folks, but it is within a pretty tight bandwidth that is consistent with our mission and ministry of wanting to help people grow in their relationship to God and to deepen their commitment to Jesus Christ.
And a few of us old Baptists will fit in that crowd too.
A few. I don't know as much. I don't claim to be an expert witness on the Baptist.
I'm an honorary Methodist. I'd like to ask the question from the business model perspective. And this plays into traffic, it plays into water, sewer, all of that. In your business model, do you anticipate an occupancy rate in the wintertime that would be similar to what's now potentially in summer? In other words, will all this be going on all winter long?
No, I don't anticipate it, which is not to say we wouldn't love to see it. Certainly, I mentioned earlier that our occupancy rate at Assembly Inn pre-COVID had reached 50%. There's a recognition that there's a little bit of a natural ceiling as long as we're pursuing our mission and ministry on how far those occupancy rates can really grow. Because we are committed to bringing people here for particular purposes within the boundaries of our mission and ministry. It is going to be difficult for us to bring adults here Sunday through Friday during the fall, winter, and spring. We bring church professionals here during that time. We bring people here for various educational and recreational experiences here during that time. But we are not a corporate retreat center. We don't market to law firms. We don't market to private businesses and encourage them to come and use these facilities, which would be the natural way to grow that occupancy rate out beyond. We can achieve an occupancy rate, we think, of 40 to 50% with this new lodge, as we have with Assembly Inn over the last 7 or 8 years since Assembly Inn was renovated. And that's an important component to the discovery of the opportunity that we have here, by the way, the renovation of Assembly Inn. And so we do feel like within our existing programming that a 50% occupancy rate year-round is possible. That would mean taking a lot of the folks who are currently staying elsewhere in Montreat and filling that lodge with those folks during the summertime. And so in the summer, having a close to 100% occupancy rate during that really busy summer season. And then in the fall, winter, and spring, being busy on the weekends, certainly the beautiful weekends. People who are on church retreats and on seeking Sabbath experiences love, the change of leaves, just like folks who come up here for other reasons. So we do very, very well on the weekends and on holidays. And of course, when we have really attractive conferences during the week that attract church professionals, people who can afford to come here during the week and take the time off to be here. But you're not going to see the kind of activity we don't perceive, given our mission. You're not going to see the activity in this lodge and on this property year-round the way you would June and July.
I read in some of the documentation that there's some collaboration with the college and so forth during the winter. Will there be students in that traffic there? Just curious.
That's a good question. So the general answer to your question is no. What you may have read, and I alluded to this earlier when I talked about how we went through a plan for all of our 13 lodges and how it yielded some opportunities for us in terms of mission and ministry. The college is in a period right now, very fortunately for all of us, a period of some enrollment growth. And some years ago, we realized there are 3 of our lodges that are on Florida Terrace and or Lookout Road, right there just above what's considered to be the General College campus here in Montreat. We have used, as long as I can remember, for the housing of our summer staff in the summertime, but have never used it in the fall, winter, and spring, and they haven't been in great condition. Some years ago, we realized that the college had a need. We approached the college about whether they had an interest in renting those facilities. And so now those facilities are essentially occupied year-round, which I think goes to the heart of your question, by our summer staff in the summer, by college students in the fall, winter, and spring. This is very good hand-in-glove relationship with the college. It's a win-win-win for all of us because Everyone who stays there now is staying in a nice facility, and so we appreciate that. The way that impacts, the way this new lodge project potentially impacts that actually is, and of course the purpose of this lodge would not be to house college students on the property. I don't think we go to all this trouble to do that. No offense to my friend Paul or anybody else, but the purpose for this is very clearly to serve our distinct mission and ministry. The way it might impact, for example, I can see in the foreseeable future, let's take Winnsboro Lodge, for example, which is directly across the street from Howerton Lodge. We don't use Winnsboro a whole lot, as I said earlier to your question, in the fall, winter, and spring, but we do need it sometimes. We do rent it sometimes on those weekends. This lodge could make Winnsboro available to the college. You know, it's literally situated right directly adjacent to the college campus. So there might be some domino effect, a positive impact on the college's lodging situation as a result of bringing this new lodge online. But back to the purpose for this particular lodge, no, we plan to use it for groups. And again, he can speak to the design characteristics of how we plan to accommodate those groups, but for groups that are here to participate in Montreat Conference Center programs and retreats.
Thank you.
Okay. Mr. DuBose, where do people stay if they aren't staying on the MRA campus or in the MRA building?
In the summertime, and mostly in the summer, but this also happens in the fall, winter, and spring because we have people who live here who are part-time residents here who also participate in our programs, conferences, and so forth. But they have a number of options. They stay in private housing. I've alluded earlier to the fact, mentioned earlier the fact that we feel like there's some contraction in terms of the number of houses that are available, particularly the youth groups in the summertime here. But that's still an option for a number of our youth groups. They have the possibility of staying in other lodges in Montreat. William Black Lodge, which is on North Carolina Terrace, directly above. We don't own William Black Lodge, but it's directly adjacent to Assembly Inn and directly adjacent to the neighborhood, right above our property. South Carolina Home, Georgia Lodge, which is a commercial lodge, to use the language in the ordinance. That is on the other side of the Hayner's house on Assembly Drive. That's owned by the 5 Presbyteries of Georgia, I believe. So there are other lodging options for groups in Montreat who want to come and participate in our programming, but that aren't owned directly by the MRA. Those last 3 lodges I mentioned are not in the list of the 13 facilities that we own and operate. In the summer, in particular, because the lodging has been getting more and more difficult to find, we even have groups who stay in Black Mountain who come into Montreat for conferences, but stay elsewhere. The last option I just remembered is, of course, we have some folks who attend our conferences who stay on Montreat College's campus, and they rent directly from the college and attend our conferences and programs. Those folks, have their experience with the college. The college, of course, in its growing mode that it is, increasingly is interested in growing its own summer programming. And so as part of our strategic planning process, we recognize that we have to allow for the possibility, perhaps even the probability, that college housing might be less available to us as the college continues to grow. So again, all of these factors have gone into our decision to pursue a new lodge.
I want to build on a question that one of the board members asked earlier about hosting a wedding. Do you guys ever provide tourist accommodations to the general public?
Sure. I would say every conference center in North Carolina, probably without exception, occasionally provides accommodations to individuals who don't declare their reason for coming and call us up and ask for a room at Assembly Inn. We provide accommodations to people who have family members who come into Montreat and they just don't have enough bedrooms in their cottage and need a couple extra bedrooms. Now, we do that under certain conditions. It's a 100-room, and predominantly that activity, by the way, never takes place in our lodges. It almost always takes place in Assembly Inn, because Assembly Inn is where all of these lodges are operated from a commercial perspective. It's where people check in, where they get their keys, and so on and so forth. So Assembly Inn is where we can do that kind of thing, but it requires very, very special circumstances, not just because of the design and the architecture, but because from a hospitality perspective, it is difficult for us to accommodate sort of one-off individual kind of lodging experiences. This was made, we've always known it, but we renewed our understanding of this several years ago. Some of you may recall, I think it was 2016 or 2017. There were a series of wildfires in Western North Carolina, I think principally around Lake Lure, but we were all concerned about, as we were going through a very dry period. The Forest Service brought firefighters from around the country into Western North Carolina. We worked out an arrangement with the North Carolina, I think it was the National Forest Service, I forget the entity at this point, to house some of those firefighters while they were here in North Carolina fighting those fires. The logistical challenge of that was that these firefighters had to check in and check out. They had to check in every night and check out every morning because they never knew from one day to the next whether they were going to be in Buncombe County or Haywood County and so forth. So we had to revamp and totally remap our systems to accommodate that. And it was a reminder to us, it's like we are simply just, from a software perspective, from an operations perspective, not really set up to do that. But back to your question, yes, there will always be, a de minimis, non-substantial amount of activity that takes place in a conference center, but we don't market to the for-profit public, as I've said earlier. Our mailing lists, our advertising strategies, all of that is situated and focused toward the traditional constituencies that you would imagine a conference center like ours would support.
I'm glad you clarified that last point, Mr. DuBose, because previously you're on the record as saying you don't market to law firms.
There is a room for you tonight, TC. I told you.
That's very kind. I don't want to harp on this, but you've talked about why there are problems with the law departments. Are there other challenges? And again, if you would prefer, we're going to be talking about this with our architects, but from an operational standpoint, are there other issues with the three structures that are proposed to be demolished? I mean, a question I'm sure has been asked is, well, why not just renovate them?
Well, the fundamental reason not to renovate them is because renovating them would not help us accomplish the goals of the project and providing the types of accommodations I've already described to you. And again, from a design perspective, Nathan and Chuck can speak more directly to that. Our guests, anyone who has spent the night in law departments or spent any length of time in law departments could testify to the condition of the place. 120 years ago, whenever it was built over what is commonly referred to as a spring, what I think the Army Corps of Engineers would classify as a water seepage. And so if you can imagine the mold and mildew problems that we might have in a typical Montreat home and apply some factor, I'm not an we discovered in our studies would be prohibitively expensive if we were to renovate, and in spending all of that money, we would not accomplish the goals that we set out to achieve with the project, and it would not be a good stewardship use of our resources. And so from an operational perspective, it was a very easy decision to say a prayer over Lord and thank law departments for its service and look to the future.
Okay. May I ask a question?
Sure.
There's a conflict in my mind I want you to address. You talked about a contracting number of available homes, but yet summertime has dropped. Summertime right now has a little bit less people. My conclusion is there are more people living in Montreat year round or here in the summertime making less homes available, or is that not fair?
Both are accurately represent my testimony, what you said. There are fewer people attending conferences in Montreat in the summertime, roughly 2,000 or so, fewer than did 20 years or so ago. Those 2,000 people or so are now coming to conferences and church retreats and other times of the year. So there's been no overall decrease. And it is also true that, and I don't have like demographic data and I'll make that clear. I don't have demographic data on how many people live in Montreat today and don't rent their homes versus 20 years ago. So I don't have any firm data to confirm that for you, but I can channel the testimony of the folks who work very hard each year to find housing for our guests. And it isn't always, by the way, just a matter of whether the houses available in total are good for renting. So it also goes to the experience that people have when they come here, which is another reason why the lodge itself offers advantages and flexibility and the scale that it is. Groups come in all shapes and sizes who come to Montreat. There are small groups of 6, 8, 10 kids, for example, for a youth conference, and there are groups of 40, 50, 60 kids. When a group of 60 is looking for lodging here and they can find 5 houses that will each sleep 10 kids, that is not an advantageous opportunity for them, because if they have kids who are on, 2 houses on South Carolina and 2 houses on Shenandoah and 1 house on Kanawha, getting those groups together, together at the end of the day to download and process everything they've heard in small groups and in worship and in plenary that morning is a logistical challenge for them. And so it isn't just a function of the total capacity of housing that is available in the valley. It's also a question of mixing and matching. And I think our architects have done an outstanding job, which again, they can speak to, of designing a lodge that fits a number of different group scenarios so that the lodge will accommodate 1 large group. It will accommodate 2 groups of different sizes. It will accommodate 3 groups of different sizes, giving us a lot of flexibility to mix and match and help folks who come here find a suitable location that is convenient to our campus across the street and walking distance to just about everything they're going to do.
Is it fair to say that you're developing sort of a menu of lodging facilities? So that way the different guests have a way of plugging in. And then currently, if you can't address that need, where we used to drive to vacation, now they have the option. They'll go to St. Simon's, they'll go out west, they'll go up north. It's not an option of Montreat or no, it's Montreat or someplace else in the country.
Are you speaking to the choices people have as coming to Montreat versus other places, or you?
If the menu is very narrow in a lodging thing, and it says you can have this ensuite bathroom is a huge issue I would think for most people.
Mm-hmm.
If it's not available, they say, something, we're not going to be guests in Montreat because that's a deciding factor for us.
That is absolutely the case, yes. And in fact, as I said earlier, we don't currently have a lodge in the condition of the lodge that we're proposing to build, laid out the proposing to build. And yes, this lodge will substantially increase not only our capacity, but the offerings that we're able to provide a prospective group who's looking for a place to come. Yes, definitely.
And this is my last question, Mr. DuBose. Talk to me about the importance of this project to PCUSA and MRA. Why is this expansion needed?
Wow, how long do you have?
I hate to, I've been very willing to let Mr. DuBose go to this point, but I think speaking on behalf of PCUSA and the importance of it is probably a little bit outside of.
I will certainly rephrase the question. Thank you, Mr. Doerr. Tell me why this project is important to MRA. Why is the expansion needed?
Well, I don't want to quarrel with Mr. Knorr here and wouldn't presume to. I am a lifetime Presbyterian, the son and grandson of a Presbyterian minister, the nephew of a Presbyterian minister. I have been active professionally in the Presbyterian Church on and off for the last 20 years. So I do have a perspective. I'm currently on the board of a Presbyterian seminary. So I think I do have a perspective on how this lodge stands to benefit the PCUSA. I'll just speak though through the lens of the Montreat Conference Center. The people that we serve, once upon a time, Montreat Conference Center predominantly served the Frozen Chosen and the Presbyterian Church, who have force of habit and for the love of tradition came to Montreat. They denominational identity, when I was born in 1962, and our culture and society was far stronger than it is today. It was particularly strong in the southeastern United States. And I think it is fair to say that through Montreat pre-1983 and the reunification of the church was the only principal convening ground of the Southern Presbyterian Church. We hosted 25 General Assemblies between, say, 1925 and 1967. And in those days, the Conference Center's role for the PCUS at that time was essentially, we had a little programming of our own, but essentially the role of the Conference Center in those days was to serve, the analogy I like to use is, we were the hardware into which the church uploaded its program software each summer. Now that's a generalization, it's a characterization, but I think it's mostly true. After reunion in 1983, the Conference Center kind of had to reformat and chart its own way. And in so doing, had to begin to develop its own software more intentionally and more deliberately. We had to figure out how we were going to serve our mission and more predominantly, create our own offerings to attract people to the campus. That connected very directly to the fact that from, say, 1965 to 2021, denominational affiliation, denominational identity has continued to decline. And so as the Conference Center began to evolve, we began to work harder to attract people to come to the Conference Center. Today, the Presbyterian Church, and this is not a matter of opinion, this is a matter of fact, the Presbyterian Church USA is a smaller institution than it was 50 years ago. And the Presbyterian Church's role and responsibility in our society as a voice for Reformed theology and a Reformed understanding of Scripture and a Reformed understanding of God and how God works and acts in the world, we have to be more aggressive, more forward-thinking, more outward-reaching in terms of how we conduct our ministry. We can't assume people will come and stay in Lord apartments because they want to be at our conference center. We have to become, to use sort of for-profit language, more competitive in the way that we attract people. And so that impacts not just the lodging that we provide, it attracts the kind of programming that we do. Where once upon a time, our club programs in the summer might have a devotional every day. We have a devotional every week in our club program in the summer now because we want our kids to really enjoy coming to those programs. Similarly, with our programs, the carrot is sometimes a recreation program, and we work spiritual and educational opportunities into that program. Sometimes it's an educational program, and we work recreational and spiritual opportunities into that program. So we have to be more facile. We have to be more careful in terms of how we approach our ministry. Still today, and this is a misunderstanding about the Presbyterian Church USA, as we are facing these demographic challenges, and I can illustrate that with a statistic. This comes from the Presbyterian Board of Pensions. Roughly 75% of churches in the Presbyterian Church USA today have under 150 members. 75% of the churches in the denomination have under 150 members. Now, many of those churches will not be with us in 25 years. That's a fact. 75% of Presbyterians don't go to those churches. So as we look out into the future, there is no question in our minds that this conference center will continue to be affiliated with the Presbyterian Church. It will continue to serve, even as that service changes and morphs and adapts to the needs of the churches. We will continue to be aligned with, continue to be affiliated with, and continue to serve our predominant denomination, even as we offer up Montreat increasingly to people who aren't Presbyterian or who aren't even in a Presbyterian denomination, not PCUSA, and then continue to broaden our reach to encourage people to come here, to grow in their relationship to God, and as I've said a couple of times already, hopefully to deepen their commitment to Jesus Christ. That's what we're going to be about going forward.
Is it fair to characterize this portion of your testimony that you used to get the business, now you have to earn the business, and your viability is dependent on that?
I think that's a portion of what I'm trying to communicate to you, but as it relates specifically to the standards and to the essential character of Montreat, what I would hope that you would understand is that what we do today is a direct through line all the way back to the founding of this place. And that essential character, while it may have changed shape and may have changed implementation and may have changed the way we go about our work, has not changed since the MRA was founded. And yes, as we move forward, we're going to have to continue to be increasingly agile and increasingly creative in terms of how we accomplish that ministry.
So maybe same mission, different methods.
same mission, evolving methods, though I think to some degree, many of the core methods that we've always observed, because we're Presbyterians and we're slow to change, we have particular views on how we worship. We have particular views on how we learn. The life of the mind is very important. There are certain commitments in the Reformed tradition that we will relinquish no matter what.
Sure. You did not mention the barn dance as one of the things you offer to the community. I was curious why you didn't mention the barn dance.
You know, gosh, I figured I was talking enough as it was. So yes, the barn dances fall under a category of recreation programming that we offer to the community free of charge. That is subsidized to some degree by the lodging that we provide people who come and stay here in Montreat, along with Robert Lake Park and some of the other amenities that we offer. And again, the barn dance, to your point, sir, is a good example of recreation and how recreation influences not only community life here, but it influences the experience that people have when they come to Montreat.
And I assume that's subsidized by lodging.
It is.
And my last question, just on your testimony, is: are you obligated to pay taxes, or do you voluntarily make a contribution into the town of Montreat?
The answer to your question is yes and yes. So we do pay taxes in a variety of ways. We pay property taxes on land that we currently have that is platted for development, that we do not do programming on. So the conference center continues to own property. There are three principal blocks for those of you familiar with the geography here. Top of Lookout in Oklahoma, we own quite a bit of property there around what you refer to as the old stable area. We own a good bit of property up above Kentucky Road, and we own a good bit of property still up off of Harmony Road. So we pay taxes on that property each year because we currently do not program on it, and theoretically it has a value in the market because we could sell it for development. We also pay, I want to make sure I get this right. We also pay sales tax on all lodging that takes place in any of our facilities when the people who are staying in that lodging aren't participating in programming that we provide directly. And so youth conferences, when they are here, they don't have to pay sales tax because they're participating in programming that we have planned and designed. A church retreat that comes here and stays in a lodge, like somebody might in the fall, winter, and spring in this new lodge, is going to pay sales tax. We're going to charge them sales tax because they're doing programming that is not directly related to the program that we provide. Now, that is a very strict interpretation of what you asked what we're required to do. So that's a very strict interpretation.
So and this is relates to the viability issue. Your revenue sources then are primarily conference fees and lodging. And I don't
raising and endowment. The other accretive revenue source for us is fundraising. Our Montreat Fund, which contributes about $1 million a year to the annual budget. Voluntary gifts of our constituents who give unrestricted gifts from the conference center to support our mission and ministry. The revenue that we receive from endowment funds that have been established for various purposes. One last thing back to your previous question, you asked about other payments to municipalities. So we do charge everyone who stays in our lodge, although I don't think we'll charge you tonight, TC. We do charge everyone who stays in our lodge $1 a night, what we call a community services fee. This is collected over the year and distributed to the town, I think on a quarterly basis. It's not a payment in lieu of taxes because it's not a relationship that we get out of the negotiation with the town. Some years ago, in an effort to support and recognize the fact that the town provides municipal services, the town provides, police and so forth, we send substantial amounts of revenue to the town each year to support that. So as our lodging goes up, revenue to the town goes up. Okay. We also send not quite as much money, but a significant check each year to Black Mountain because they provide our fire and rescue.
Great. Thank you very much.
Last question I have. We as a board have to be concerned. Myself as a Christian, the Great Commission says, go get it. I'm saying I'm all for that. You as a board member says, how is that going to affect the community as a whole? How are we going to pay for it? How are we going to, it goes from everywhere from having the sewer, how much, do we have enough sewer? Is that going to take more money? And so I'm curious about that, because it's a good problem to have, but we have to be thinking about that right now. If you were to be, successful, it's not something so do you continue to think that your current funding structure being voluntary is the way it's going to continue? If this was to be accepted, and I have no decision at this point.
Right. Well, I'm not quite sure of the nature of your question. I can speak to some of the things I thought I heard you.
If you fill up, we've got sewer issues, if you look at the plan, it clearly states in that plan, there are going to be issues with the sewer, there are going to be issues with roads as we grow. These are challenges. How do we deal, how would you perceive that we deal with those challenges as a town? You pay taxes. These taxes get paid to the town? Do they get paid to the town?
Sales tax, I think, goes to the state. The property tax, I think, goes portion of the property tax.
And sewers by MSD, but your expert testimony will take more address that. So
Yes, I'm hoping we get into more of
So I
that.
think as your question relates to the specific load on utilities and whether our town's infrastructure can bear this additional activity, that's really, our experts will speak to that. I will say though, however, something that TC asked me about earlier, and that is the fact that if in fact this is a success, and if in fact we end up with a 50% occupancy rate in this lot on year round, and if in fact these people who were previously staying in other parts of town are now staying in lodge, I would submit, sir, that you were perhaps redistributing some of that activity rather than adding to the activity in the business. And the second thing I would say is, again, to remind you that 20 years ago, in the busiest season, the conference center, we had a couple thousand more conferees in the valley than we do today. So I guess my question back to you was, if we were available to accommodate it then, doesn't it seem reasonable that the town's infrastructure can accommodate a more marginal increase in activity in the fall, winter, and spring now? That's not what I would guess.
And if I could, I mean, I don't know if I want to phrase it as an objection to Chair's question, but I think it's worth pointing out that in a special use permit proceeding, and Mr. Whitlock has already directed your attention to this standard. The standard is that the use meets or will meet all required and applicable development standards. And I think questions about infrastructure, sewer capacity, water capacity, fire trash, and all that are very real and important questions for the town to answer. But I don't think, respectfully, it is something that we have to solve for the town. That's not what's been asked of us through the development ordinance, would be our position.
Mr. Chair, if I might just briefly respond to that polite
Are you
speaking
making
objection.
an objection?
Just to know.
Let's call it an objection, but I hope there's no offense taken.
The questions are going to cut both ways, guys.
Sure.
So-
And that's
Absolutely.
I'm trying to be fair here
No,
on both
it's
sides.
Perfectly fine, sir.
And I think we just wanted to briefly respond in that those concerns are exactly what this board should be thinking about, because those are the standards that are in your conditional use process. Can this use meet those standards? You can have a situation, and I'm not talking about this project, but yeah, if you have capacity issues and something comes in that proposes to exceed that, that's a problem. I'm, again, not talking about this particular project. So I think your questions are well tuned to the conditions that are before this board.
And Justin, I know, I don't want to belabor the point, but Mr. Noor makes a fair point. However, if you have a development that's proposed in North Carolina, you're required to process the application under the laws that exist at the time the application is submitted. And if there is an availability issue, there are towns that have that very issue. I work with some of them, represent folks in front of some of them. That isn't a question that was before us when we submitted our application. Respectfully, there's nothing in your ordinance that says, can you demonstrate that the town of Montreat has capacity for your project? And frankly, we have no way of demonstrating that. We're not the town engineer.
That's not your scope.
Respectfully, that's our position.
You can put things on the roads to see traffic. You can You can, increasing, I mean, all
Well,
I'm saying is,
and I want to say now, the things we can talk about, sir, like the numbers of cars going on the road, we have a traffic engineer, we'll be talking about that, absolutely. Talking about things like design elements, and I know there's an incredible amount of concern from citizens about how this fits in with the community. That's fair game, and it's absolutely stuff that we need to be testifying to.
Mr. Chairman, if I may respectfully, with all due respect to Mr. Morphus, I think the Montreat zoning ordinance very plainly states out that the applicant here, the MRA, has the burden of persuasion to produce competent material and substantial evidence that this project will meet all of the special use criteria. We've talked about the one criteria applying to development conditions. Mr. Morphus says, well, we're not the town engineer. They have an engineer sitting right there who can pick up the phone to make a phone call. You know, if he's going to be able to convince you this standard is, just to prove it, and we'll see what happens in the future, then the board is not able to do
I
its
think what the
job.
chairman's saying is, let's address that through expert testimony, not through opinion.
Sure. And that's fair. And I won't belabor the point, but I mean, we will present evidence about the standards that are in the
And
ordinance.
then we can ask our questions on.
I have some expert testimony to make there on the question. From our experience.
Well, and I'm sorry.
Object to any expert
I think,
opinion.
if I can make my objection for the record for just a second, if he's going to offer expert testimony, he needs to be qualified as an expert prior to offering that testimony. So
let me offer some testimony that may bear on the question that you asked me earlier, Mr. Chair. What I know is that that between 2006 and 2016, as we began the modernization of our facilities and began to modernize the institutions and facilities in this valley that people do associate and characterize as Montreat facilities, Assembly Inn, Anderson Auditorium, and so forth. During that period of time, we cut the consumption of water, the use of those facilities. As occupancy rates were rising as a result of those renovations, we cut the consumption of water from 6.2 million gallons a year to 4.7 million gallons a year. Not because we had fewer people coming here. We actually had more people coming here over that period of time. We actually reduced that because we were able to modernize the utility services within the Assembly Inn and the other facilities. And we're able to much more efficiently manage the use of the resources that we were drawing on in terms of electricity, in terms of water in this particular statistics case, to those facilities. So again, we feel confident that, I feel confident based on our experience as a conference center, based on our operational experience and our budgeting experience as a conference center, that we will not add an undue burden to the town. That's my opinion.
thank you, I appreciate it. Okay, it's about
8:15.
8:15.
just a question, Mr. Morphus,
I think we were done.
That's the end of the direct examination. Thank you.
Okay, so I think we're done for tonight. We are going to continue this.
Well, so I'm not sure what you mean by done for tonight. The opposition will still have an opportunity to cross-examine Mr. DuBose.
I thought our schedule was 8, it was 4 to 8, but it's 4 to 9.
It's 4 to 9.
Yeah, sorry.
Okay.
Mr. Chair, are you wanting to take a break though? Because this would be about that 1.5 hour.
Yeah, I think that's good.
mark.
That's good. I was hoping to maybe go and then get off early. So.
I'm sorry, we can't accommodate
I
that.
was trying. I was trying.
Man means business.
Where did this come
Look at the first sentence.
Yeah.
Boom.
Where did
This
this,
is marked out.
which document did this come in?
Two guys from Traffic Care Phone.
Human frail.
That's good, Ann.
Okay, so we have about 30 minutes. We wondered whether it would just start and go 30 minutes worth and then continue. If you think that's helpful.
I was just saying, this is really because it's cross-examination for
Yeah.
for the council.
Well, I don't want to hold the board members over, and so if you would rather us wait till
No,
next
we're-
time,
we're
I'm
till
happy to,
9.
if you're, okay.
We're till 9, so we're good.
Okay.
Yeah, I just wanted to give both of you the benefit.
Fair
Thank
enough,
you.
fair enough. Well, if the board will give me just a brief indulgence, Mr. DeBose, you and I have not had the opportunity to meet before, but I have the pleasure of working with your wife on a nonprofit here in Western North Carolina. Yes, I learned that for the first time tonight too. Well, and I just wanted to say for a second, being a Presbyterian as well, this won't be the first time I've been in a room of Presbyterians who don't necessarily agree on everything. So, well, I know, and so.
Do you think any denomination will agree on anything?
I do think at this point, I need to get in the record that I was raised Presbyterian and I'm a graduate of Presbyterian College. So while we're all, kind of making a competition out of this, right. So anyway.
Well, there's a bunch of us here tonight. I just wanted to say, I hope we can appreciate that while we may disagree, I will not be disagreeable. And that ultimately, we are all living here in Buncombe County and we're working for the same benefits for our community going forward, no matter what the board decides. So I had just a couple questions based on your testimony. I am trying to do.
What does it matter?
Could I steal one of these here?
You may borrow it.
Thank you. Is that better? Okay. So one of the questions I wanted to ask you about, I know we've had a lot of conversation about hotel versus lodge. And I think I wanted to kind of start with the occupancy rates that you talked about. And I know you say the purpose and plan that the MRI has for this use is to have it continue in the same kind of marketing that you've done in the past, serving the same populations you've had in the past. That's the purpose and plan. But in the world of zoning and how these buildings get built, if, heaven forbid, we didn't still have you as a leader at the MRA and someone new came in and decided for whatever number of reasons, financial or otherwise, that they wanted to use this facility in a way that was different than their plan, than the plan that you have. There's nothing in your application that you've agreed to as a condition to keep those same occupancy rates. Is that correct?
No occupancy rates, I don't think are referenced in the proposal.
Okay. And would you all accept as a condition, some kind of condition that said you can use this for your intended purposes so long as you maintain current occupancy rates?
Well, so the direct answer to that question is any conditions that come out of this hearing would have to be approved by our board of trustees. I'm here tonight representing our board, and so the board will have to approve it. They've approved the submission of the application that's been presented. Now, I do represent the board. I do have a good feel for what the board would accept. That would certainly have to be something we could discuss.
So you're not sure would need to go to the board?
I'm not sure they have to go. Well, no, I'm sure they have to go to the board. I'm saying that sometimes have a pretty good idea of how the board is going to respond to certain requests. So, we're not operating completely in the dark on how the board would behave based on my recommendation, but it would be subject to board approval.
What would and my question was, would you agree, or do you think the board would agree, since that matches what you have right now?
Well, we don't have the proposed lodge right now. We don't know what the potential for the future of the rates are. I'm afraid I'd be reluctant to put any limits on the ability of our ministry to achieve its mission in the future related to the occupancy of a new lodge or hotel. You can make a proposal, but I'm not saying that I would agree to it.
So in that context, it is possible, again, if this was wildly successful, that those rates could go up. And in the context of zoning, again, we have the current use and how much, how many rooms there are and the traffic and other facilities that or impacts that has. This is double that current size with 20 room, you have 20 rooms currently, and it would be 40 under the new proposal, correct? Okay. And with the menu of options that I think one of the board members asked about, which was, this is just giving you a different item on the menu to offer for those. Is that fair, kind of in how the board member put it to you, how you understood it?
It is, and that's primarily, though, a factor more in the fall and winter and spring, where occupancy rates are much lower than they are in the summertime.
Okay.
Summertime is really more of a capacity issue, responding to the needs that are currently exist in the market and currently available for us to build this out.
And if I understood your testimony, you haven't seen an overall drop in the people coming to Montreat for your services. It's just been at different times of the year. Instead of it being more in the summer, it's peak spread out.
12 months of the year, yes, and it's operated. I mean, it does change year, of course. We did a conference called Evolving Faith years ago. Drew, 1,400 people. That year we had 12,000 employees. Following year we had 10,500. Now that 1,500, and the snake, and that's one with the snake. So it just depends, but it's an advantage of 12,000.
Generally, it's been consistent. Okay. So the lack of this menu option has not resulted to date in people choosing to go somewhere else in your overall numbers throughout the year.
It has not resulted in a final impact on that consistent business, no. And so, yes, like I said, we would hope to increase the ability to bring people who are choosing not to come here in the fall, winter, and spring, and get them to come here and stay in this lot. Because it's a function of math, if you take off the menu 3 lodges that people are staying in very sparsely or not at all in the fall, winter, and spring, replaces with a lodge that on the weekends, in the fall and the spring, particularly in the holidays and some other times we're having conferences, you're going to see a legitimate increase in the number of people in the fall and spring who do attend conferences in retreat.
Wanted to hit on just a couple other things that you had talked about. You had mentioned the question about commercial delivery. Again, it's not your intent to have lots of weddings or have lots of events necessarily that would demand commercial deliveries. But again, let's say someone else is in your position who makes a different decision about how to use this. That could happen for this facility. It's just not currently the intent of the MRA.
It isn't currently the intent of the MRA. And I have to say, there are other constraints that would probably make it difficult for the MRA, in the way it is currently constructed, to substantially change its business model. So, for example, a board member earlier tonight asked about taxes. And I mentioned where we do and don't pay property taxes. Because we don't pay property taxes, we are constrained from ways in which we can market. And so for us to change our business model, if your question is, could we greatly expand the market for which we're going to use this facility? If we're going to pursue non-missional business intentionally, that would require a restructuring of our mission and ministry for the board to do that. It would require certainly some changes in our tax structure and how we operate as an institution. And then that's a whole can of worms. I mean, good luck to the person who tries to get that done.
Well, and I guess the point I'm trying to make is without conditions, is that something, a condition you'd be willing to agree to?
I'd like to see it, I'd like to see how it's written, and I can't answer that question until I know what you.
And I think the point I'm trying to make for the board is that unless these realities are locked in conditions, an intent today may not be a reality tomorrow. That's something to be keeping in mind in the approval process or consideration of this project.
Can I go back to the first word you said? You said commercial rates or commercial use? Are we talking about pricing or use?
We were talking about the commercial, the commercial delivery concerns that I think member James had talked about. Is that what if, for example, down the road, the MRA decided to spin this property off and have a wholly owned subsidiary business or nonprofit that just did weddings there? Unless there's some kind of condition that would regulate that, the commercial use, which currently isn't part of your intent, could go up and there'd be nothing to stop it because this is that opportunity for that.
May I have a question? Is MRA strictly a 501c3?
We are.
So here's a big hypothetical, which I think you might be going down. What if the MRA went bankrupt and all the buildings are sold? And Marriott comes in and goes, we're going to take over the hotel. Is there anything with your 501c3 that limits how these properties may be sold in the future or marketed because of your charitable status?
I don't know that I have the encyclopedic knowledge of the charter. To answer that question, I can come back next week and probably provide you a better answer to that question. I do know that in 1897, and then in the subsequent revisions to the charter, the property here that was entrusted to the MRA by that time, the Presbyterian Church of the United States, was intended for the perpetual use of our property for the mission and ministry, to support Christian ministry, Christian mission, and education here in the valley. These hypotheticals are kind of hard to answer, but I will tell you this, again, the best answer I can give. If the MRA goes bankrupt in Montreat, this town and valley are going to have a lot bigger problems than what happens with this lodge.
Agreed. I have had business working with 501c3s. I do know there are certain parameters in which they can be unwound and that the properties can then be just, sold. I think it would be very important for both parties to look into that and answer that question, because that may allay a lot of people's fears.
Right.
So
I
just
know,
a little bluebird there.
I do know that our board is empowered to buy and sell property in Montreat. In fact, that's how we built the facilities originally in the valley, was through the sale of lots and land in the valley. So I do know that the board's empowered to do that, and within certain circumstances, the board is empowered to place restrictions on property. I don't know, and I'm not a trust lawyer, so I don't know whether the board has the right to encumber future boards in perpetuity through a condition of.
Well, this is more of a situation where it went bankrupt. There are parameters when a charity goes bankrupt. This is different from just unloading a property that you want or not.
No, I'm just saying that in a workout for bankruptcy, I'm not sure the board today can make a decision that would be valid in a court of law as a result of that kind of.
Well, and for the benefit of the members, I'm mainly making this point so that y'all think about conditions, because that, once you put a condition on something like this, that runs with the property, no matter who owns it. And so that's the point I'm trying to make as you think about this, is to think about those conditions.
I was going to ask you to follow up on that. That's what I was trying to understand. You're saying then a redevelopment of a lodge is not necessarily objectionable. It's the use of that building is the objection. So that's why you were thinking about conditions related to its use.
When I want to be clear, I'm asking about whether the MRA would accept certain conditions.
Okay.
That's all I'm asking. I'm not saying we'd be agreeable to this if it had them. I'm just asking whether they would agree to them, because that's part of this process.
Okay.
And so unless there are other questions for the board members, I will move on to what will probably be my last point. You got to ask about student housing, and I guess I'll go in the same thing. You're planning in the same line of questioning. You're not planning on this being used for student housing during different parts of the year. But again, is that a condition you would consider putting on this project to keep that from occurring?
No question. I would certainly consider that, as I just testified. I can't imagine a future use of this property that would meet that circumstance. Again, I don't know what limits, legal limits there might be around my ability to accept such a condition. But that is certainly not envisioned as a use. I think it's more likely to go back to the previous unlikely hypothetical that the conference center would go bankrupt before we do that, because this property, once developed, is going to be, either second only to or equivalent to, as a hospitality experience, the one that we provided Assembly Inn, albeit for different purposes, different tastes. So it's it'll be kind of a last time.
Well, I'm just struck by the fact that the MRA was incorporated, I think it was 1897.
1897.
1897. And it's amazing what occurs today that didn't occur then.
Yes.
So I'll just, if I can have a moment to confer with my client for a second, I think those will be my questions. I would never want to cut you off.
What I would say is, you go back and look at those founding documents, it is more amazing what is consistent and what continues to hold true today in Montreat 124 years later than that was how, it's in essence, the traditions, the history, the through line from 1897 to 2021 is remarkably consistent. It is different in implementation. It's different in terms of the conditions under which we've been able to do our ministry. But nevertheless, that flame has stayed lit for 124 years, and you can find that through all those documents and exhibits. I'm not contemplating running this.
I would think not. We hope you fulfill the Great Commission.
Indeed.
Those would be my questions.
Good evening, Mr. DeBose. Good evening, Mr. DeBose. We also have not had the chance to meet. My name is Jamie Whitlock. It's a pleasure to meet you this evening. Appreciate you being here. Josh, could I get my screen broadcast, please, sir? Try this again. So, Mr. DeBose, I wanted to try to see if we can maybe, at least for tonight anyway, again, put this lodge hotel distinction to rest. And you were here when I asked some questions of Mr. Adams, weren't you? And I asked him to look at this definition of a hotel in the Montreat zoning ordinance, right? And
I will tell you in advance, I can't read that.
okay.
I'm gonna read it to you.
And
Reading it correct.
I might do that. I believe you testified that you were I can't remember the language you used, but perhaps the principal for the preparation of the MRA special use permit application, correct?
From the staff perspective, conditional perspective, that's correct. Not from the zoning expertise, architectural technical expertise.
Understood. And as you understand it, though, that is an application to operate or for a special use permit for a hotel, correct?
By the terms of the code, yes.
Okay. And if we go back to the definition of a hotel, it is a building or buildings in which sleeping accommodations are provided and offered to the public for compensation, in which the rooms are usually occupied singularly for rent, and in which there is usually a kitchen and public dining room for the preparation and service of meals. The term hotel includes lodges, inns, and motels. Does that sound accurate to you?
Sounds like what I heard earlier.
Okay. And I think that definition is largely consistent with your testimony this evening about, yes, the MRA does from time to time rent out our rooms to members of the general public. And I don't want to misstate your testimony, so please.
Well, yes, that is true. And it's also true, when I read that, the word singularly jumps out to me. we rent to single groups. In other words, oftentimes when we're working with a group who comes to the conference center, a group from, First Presbyterian Church of Asheville, North Carolina, we'll work with a single person. We'll rent through a particular entity who will rent that lodge and take over responsibility for that facility for the period of time that they are renting it.
But I believe your testimony this evening was, even for this proposed lodge, should this board allow the MRA to proceed, and should you ultimately construct and operate it, it would be open to members of the general public under certain circumstances, correct?
It could be, though operationally, we would not really be incented to do that, because when you're renting to individuals, you need a front desk, you need a commercial center existing usually close by, most often obviously within the structure itself. There's a possibility that on an overflow basis that we might do that, but it would be connected to a larger group that was connected with another facility. And so, it would be something done in concert with something that was going on that was larger than our property. So if we had, larger than one property, one facility, that's, in other words, for example, a group would come here and do a conference that would that would attract 300 people who would come here. Okay. Those 300 people might come here as individuals, but they're here to attend a particular conference. We would generally work sometimes with individuals directly. More oftentimes we work with groups when we're getting it to a number of that size. So there would be a mix, but it would be much easier for us to accommodate that mix at Assembly Inn than it would in this lodge because of the lack of the commercial center available there.
Understood. And so, and maybe I can tie this up this way. So going back to the definition of a hotel and the fact that you have submitted to the town and to this board an application for a special use permit to operate a hotel. If you are granted that special use permit, this is the only definition that's going to govern the use, correct?
I'm not an expert on zoning and ordinances, but
is there a definition of lodge in the zoning ordinance to your?
I'll ask TC to weigh in, but what you say sounds reasonable, but it's not my area of expertise.
Is there a definition of lodge in the zoning ordinance to your knowledge outside of this one?
I'm going to object. He's asked and answered the question.
I'll move on, Mr. DeBose. Mr. DeBose, I believe early on in your testimony, you talked about in the context of the history of the MRA and when the MRA started to look at, the potential need or more with the condition of the lodges, you spoke about a lodge analysis. You recall that?
We did an analysis of our lodging needs, yes.
And was that like a report that was reduced to writing or?
It certainly included a lot of writing, yes. It was a report that was presented to our board at a board meeting that included PowerPoint presentation, verbal testimony, a mix of things.
But not a formal report?
Not a spiral bound McKinsey imprinted report. It was done internally. And it was done by our staff. It included interviews of conferees, cottagers, and other folks, and all of that got loaded up into a report that we gave to our board. Board members actually participated in the study itself, and a committee worked on that as well.
I believe, again, going back to your role as kind of the principal architect, if you will, of the MRA special use application, you testified earlier, and let me see where, that it was not the purpose of the lodge to do any joint housing or any collaboration with the college, correct?
That is not the purpose for which we are pursuing the permit to build a lodge.
Okay, and I guess my question on that then is why does that repeatedly show up in your application as justification for the lodge?
I don't know. I know it shows up in the, I'm not sure. Can you cite the specific references?
I'd be more than happy to. So right now, and this is in, I'm looking at your version, tab D. In your response on page 5 to section 310.625, that the location and character of the use, if developed according to the plan as submitted and approved, will be in general conformity with the adopted policies and plans, including the comprehensive plan of the town of Montreat. And then it cites the town center 1 area and references the possibility exists for collaboration between the MRA and the college to address housing needs. It then goes on, the joint use of facilities could be encouraged here. And I would represent you, that's repeated in other places throughout your application as well.
Yes, we're repeating that language in the application because that language directly applies to the property that we're seeking to develop. So we're quoting, I believe, if I'm not mistaken, we're quoting the town's 2008 strategic plan and its suggestion of intended use for the property. So yes, the college is included in that statement, but that's not the part of the statement that relates to this permit application.
Okay, understood.
Is that right, Chuck? Just making sure.
We can ask Mr. Kreckelberg when he testifies, Mr. DeBose, but thank you. Let's talk briefly about some of the 6 existing lodges on the property. To your knowledge, none of those existing 6 lodges have ever gone through the special use or under the prior zoning ordinance or prior versions of the zoning ordinance. I think what was referred to as a conditional use process before the Board of Adjustment. Is that correct?
I know that many of these lodges and their use as lodges predate any permit or permit application process. I supplied to the town, and I believe the town supplied to you a report on the permit status of the 6 lodges on the property. I don't have that in front of me. Maybe you do.
I believe you testified that the MRA acquired Walnut Lodge in 2016 and 2017, which you described as a private residence. Since the time it acquired Walnut Lodge, has the MRA applied for a special use permit and come before this board for a hearing like this to operate Walnut Lodge as a lodge?
I'm going to object. The application is not for Walnut Lodge.
It's on the subject property, Mr. Chair.
That's all.
Proceed.
Thank you.
So the question is, we did not apply for a permit to operate the lodge as a lodge. We call it a lodge because all of the other properties on buildings on that property are called lodges. But in effect, it is operated, as a small lodge. It says lodging for small staff, mission volunteers, summer staff, and that sort of thing. It has not been a large guest facility.
I believe in your application, it's labeled with an I for institutional use, correct?
That's true, because the people who stay there are staying there through the institutional mission and ministry that we're providing.
Okay. I wanted to ask you briefly about the Lord Apartments or the Chester Lord House. That is one house or one of the existing lodges that you are proposing to tear down as part of this proposed hotel development, correct?
That's correct.
And I believe if I wrote it down correctly, you referred to that house earlier as the lowest ornament on the tree. Is that accurate?
It is accurate from certain perspectives. We do have another lodge, McCallum Lodge, that we currently don't rent at all. It is at the base of Graybeard Terrace. And it, from an interior perspective, is in similarly terrible shape. The difference between McCallum and Lord is that the bones of that structure, the layout, the design are very, very good. And so, and it remains of the 13 lodging facilities that we have on our campus. McCallum's one right now we actually don't have a plan for. So, but with where Lord Apartments is concerned, yes, of the lodges that we're currently operating, it is the least desirable from a hospitality perspective. I think that's a fair characterization.
And I understand that from a hospitality perspective, but from a historic perspective, surely you recognize that that is largely recognized as the first house and first building constructed in Montreat, correct?
I don't know. Several people have made that claim. I don't know that one way or the other. What I do know from a historic preservation perspective is we have a commitment to historic preservation here in Montreat. And we have invested millions of dollars to preserve the facilities here in Montreat that do matter to the people and do matter to our mission and ministry.
Counselor, if you would get to a point here.
Okay, well, and I can. Thank you.
Yes.
And that's what I was just to tag on what Mr. Whitlock said. I assume they will finish, and then there are a few other folks that's standing that may want to cross next week as well. And I have just very limited redirect.
Okay.
Thank you.
All right. Thank you. Okay.
Are we beginning at 7 next week? Or are we gonna bring it up earlier in time?
I think we agreed early in time. Right? Oh, because, that's a good question. From a designation of known place and time, do we need to, if we were going to change that, would we need to place notice?
Ask me that again. If you're going to change it from here in a different date.
Our date is the 28th, which is our regular scheduled meeting, which is regularly at a certain time.
Is it a week from today? Right.
And if we change that time,
Did change that time.
Yeah, I think you did change that time the last.
We
So-
talked
so-
about-
It's 4, yeah.
Okay.
And so what we'll do is we'll just, this matter will then be continued until 28, starting the 4th.
There you go.
Okay.
And Mr. Chair and board members, I think the parties are also going to just talk and try to come back with some additional planning that might help with presentation of witnesses, just from the kind of amount of time it took us tonight in thinking about how things will go forward. So we'll talk with Golden or Brian, sorry, and try to.
and if you
reach
guys
an
don't
agreement.
mind, you would really help me. I'd like to ask if you would. I want to make sure that our exhibits get put in an orderly way. So I'd like both sides. You had mentioned that. So when we review, we can review properly.
We will. Thank you, Mr. Chair.
Okay, if that's all, I guess we're going to
Motion.
hear a motion to adjourn.
Don't adjourn, just continue.
Continue, correct.
Yes. Motion to continue. Okay, and I'd like to remind everybody that we are under the obligation not to communicate this to anyone. We are continuing this process, and please don't open the mouth. Have a nice day.
Do you want to take these and redistribute them?
Yeah. Yes, yeah,
We
we'll
prefer-
keep.